and the district judges who are joining us online, the additional district and session judges, the special judges, my colleagues, judicial officers, the judicial officers of the district council courts, senior advocates, senior members of the bar, law students, other stakeholders, and the eminent resource persons who are present with us today. Ladies and gentlemen, a very good morning to you all. We thank on behalf of the High Court of Meghalaya and the Meghalaya State Legal Service Authority and also the State Judicial Academy, we thank all the participants for a very overwhelming response to our request for this training. You have turned up in big numbers, though many of us are burdened with the Sisyphean task of our regular life and also keeping up with the World Cup. You have turned up in good numbers. I am very grateful to all the participants here today. I'm sure with the sessions that we have in hand, it will reinvigorate us and also help us, put new life into us. In the words of the former Vice President of the United States, let us unburden ourselves by what has been, and let us start anew here today. Today we will be moving on to the technical sessions. Before we commence with the sessions, I encourage all the participants to kindly engage actively in the deliberations. Let it not be a monologue or just a dialogue. I expect participation from the various stakeholders who are here, the LADCs, the legal counsels, the law students. You should understand the importance of such a program. It's not only in acquiring knowledge, but these kind of sessions are important in exchanging perspectives. What our eminent resource persons may have experienced, what you have experienced may be something new. So it is a platform for exchanging of ideas and also exchanging your experiences on the field and collectively reflecting on the challenges that we have and the opportunities that define contemporary legal practice. Now we will commence to the technical session. I kindly request Joint Registrar Sir, B.M. Sangma Sir, to kindly escort Shri Gajanan Chavan Sir, the resource person for this first session, to the dais. Due to paucity of time yesterday, we couldn't give a befitting introduction into Sir's experience. Sir is a very senior member of the bar, having about 44 years of experience in the legal profession, probably more experience than most of us have even in life. He has conducted over 1,500 NDPS trials, over 3,500 sessions trials, conducted over 150 POCSO cases, and he was the president of the District Bar Association of Thane twice. He was also the elected member of the Bar Council of Maharashtra and Goa, for the former chairman of the Bar Council, and director of the Bharat Ratna Dr. B.R. Ambedkar Advocates Academy, Research Center at Panvel. He was also the chief editor of the Handbook on Criminal Practice, published by the Bar Council for the newly enrolled advocates. Sir is also an author of 3 criminal major acts, of the new major acts in Marathi, and author on cross-examination in criminal trials, also in Marathi, and delivered a number of lectures in criminal law in Maharashtra, Goa during the last 10 years. Sir is also associated with the Mamta Bal Sadan in Pune, an orphanage, since the last 30 years. Sir is Sir is also a celebrated author and speaker. Since quite a bit of time has passed, so I will not delay any further. So we request Sir to kindly take the sessions. I think it's befitting that Sir has specialized in the criminal side of the law. So it's only befitting that a person of such stature takes up the sessions. For the first session is preparation on criminal trials and defense strategies. Sir, please. So if you want, you can.
No, I'll be comfortable here. No issue. Namaskar and very good morning to all young, lovely lawyers from Shillong. we have spent 2 days here, and it was told by Her Ladyship, Honorable Revati Mohite Dere, that the people here are very lovely people. And Shillong is said to be a clean city. Friends, Ladyship was a very popular and respected judge of the Bombay High Court, well known in the state of Maharashtra, very big state, and also a neighboring state, Goa. So it was she who gave this honor. Myself, our senior brother, Jayanta Zaibhave, who is supposed to be the mentor of Bar Council of Maharashtra and Goa. He is one who has initiated this legal education for the young lawyers and kind of refreshers course for the senior advocates, because very new concept of law are coming forward, and so as to meet them, we must have a continued legal education so as to stand in our profession. My another brother, Rajan Salunke, is one of the eminent lawyer in Thane district. He is known for his modesty, his gentlemanship, and deep knowledge in civil and criminal law. Friends, today we'll be talking on the criminal trial. I pay my respect to all the judicial officers of Meghalaya National Law University, all the office bearers and members of Shillong Bar Association and High Court Bar Association. I also pay my regards and respect to the honorable judges who are listening to this program online, and we are really thankful to the Advocate General Sir and his registrars, the officers of the court, for giving warm welcome to us. We will not forget our visit to Meghalaya. Now, before we proceed with the criminal trial and its preparation, etc., I would like to know, my brothers would like to know, how many of you are legal aid defense counsels? You can raise your hand so that we'll come to know. I believe almost 50. How many of you are legal advocates? Yes, there are many, 10, 12 people. Wonderful. How many of you have completed 10 years of legal practice as an advocate? Yes, I see few of them. At least 25. And how many of you are below 5 years? Good. So quite a good number. This is also more than 30. Now, friend, they say that a criminal lawyer, criminal advocate, a defense advocate, or a prosecutor who represents the state in the court of law, he must possess a strong common sense. Strong common sense. We see that common sense is uncommon. Second quality of him is presence of mind. You must be on the guard. You must be ready. What witness will say? what is his demeanor, what is his conduct in the witness box, whether he is telling the truth or he is exaggerating the account more than what has happened in the incident. So presence of mind, changing our way of cross-examination, you must have best comprehension within a fraction of second. And these two qualities you will develop as you work more and more in criminal trials, whether as a prosecutor or defense counsels. Now friends, some cognizable offenses has taken place at a particular place. You know that FIR is launched by somebody, law is put into the motion by somebody at the police station. The officer who is in charge of the police station, it is obligatory on his part to record it in writing, to register, give a crime number to it, crime registration number, what is called CR number. His further job is to take entry and record gist of the allegations in the FIR in the books maintained by the police station for that purpose, as the state government has prescribed. And his further job is to assign investigation of that crime to a particular officer. If the offense is serious, like murder, dacoity, robbery, it will be investigated by the senior officer. If it is a middle kind of offense, outraging modesty, theft, etc., it will be assigned to the junior officer. Now the question would remain as to what is investigation. Investigation is finding out the truth. Please try to understand. The complainant has come to the police station, he has lodged the FIR, it is written on the paper, it is taken entry in the registrar maintained by the police station. He doesn't know whether he has told the truth. He doesn't know whether he has concocted a false story, made false allegation against the accused person. And that's why there is a presumption of innocence of the accused till his guilt is proved by a full-fledged trial. You know that. Accused is presumed to be innocent till his guilt is proved. So investigation part plays very important role to find out the truth, then to find out the witnesses, either eyewitnesses or non-eyewitnesses, and then to collect the evidence in support of that allegation, to substantiate, to support the allegations made therein. And ultimately, upon completion of the investigation, within 60 days or 90 days, and in some cases like NDPS Act, maybe 180 days, with the permission of the special judge, charge sheet is filed in the court of law. My first advice to the young lawyers is to read the charge sheet thoroughly from the beginning till end. From the beginning till end. Read each and every paper. Read it twice, thrice, so that it will generate some kind of defense, some ideas how to retaliate with the allegation they are made in the charge sheet. That will give you ideas how you are going to proceed with the cross-examination of the witnesses. They may be brought to the court by prosecution. Supposing there are 10 witnesses. Prosecution may choose to examine only few, 5, 6, 4, as he thinks it fit. If he thinks it fit that 5 persons are sufficient, he may examine 5 persons. Not necessary that he would examine all of them. You understand? Do you get me? आपको समझता है? Say yes at least. No misunderstanding? I am audible? Yes. So the charge sheet is given free of cost to the accused. No charges is to be paid. It is a matter of right. And he is supposed to get the complete, legible, readable charge sheet from the police. So the accused who engages you or whose job is assigned to you for defending him will hand you over that charge sheet and say, "Sir, defend me." Yes. Now you have studied the charge sheet carefully. What is required to be done is to have a better comprehension of the gist of the charge sheet as to what are the different allegations made against the accused under different sections of penal code. Bharatiya Nyaya Sanhita, BNS 23. Then that will generate your more and more reading of the charge sheet. First advice is to be a master of facts lying in the charge sheet. You must be master of facts. You must know the name of witness. You must know what he states in his charge, in his statement under section 180 of BNSS, Bharatiya Nagrik Suraksha Sanhita 2023. What he alleges against you. What are the loopholes you find from his statements? What are the contradictions, variants you find in the statement of one witness, who is an eyewitness, who is the complainant, and another eyewitness who is equally was present over there? You must find out the lacunas lying in the charge sheet so that you can place your defense perfectly. You be master of facts. Try to find out inter se relation between complainant, his witnesses. 2 witnesses are there and the complainant is their real elder brother. You can brand them as interested witnesses. Law doesn't say that interested witnesses will be thrown away. Law says their evidence will have to be scrutinized very carefully by the learned judge at the time of assessing evidence while passing the judgment. Careful scrutiny of the evidence of interested witnesses. Their evidence cannot be plainly thrown out. Then you will find that the panchas used by the police, law says they must be independent of accused and the complainant and the state. They are not supposed to be interested in someone, but you will find the relation between the complainant and the pancha witnesses. They are either related or they are close friends. They may be staying in a different village, but he must be a brother-in-law. She must be a sister-in-law. She must be somehow related to the complainant and eyewitnesses. So you can jot down their inter se relations. While reading the charge sheet, take kacha notes, rough notes, as to what this witness says, as to what this witness says, what the other pancha witnesses says, and try to understand as to what the charge sheet contains. what contains in the charge sheet, I'll let you know. It is, FIR is there. Statement of witnesses under section 180 BNSS. Statement recorded by police. Statement of same witnesses or few of them recorded by the learned magistrate under section 183 BNSS. Now I tell you, although this statement is recorded by the magistrate during the course of investigation at the request of the police officer investigating the crime, law says it is not a gospel truth. It is at par with section 180 statement recorded by police. It doesn't carry any more authenticity than the statement recorded by the police. It is subject to the cross-examination. It is subject to the testified during the trial. It cannot be called as an examination in chief only because the statement is recorded by the learned magistrate. You will find number of judgments. So I was telling about the statement of witnesses. Various panchanamas. Spot panchanama, panchanama of the clothes on the person of victim. He may be a deceased also, he may be an injured person also. They may have stains of the blood, they may have stains of the mud. Clothes of the accused for the same purpose. Then the weapons, articles found at the spot. You may find some weapon of assault, one lathi, iron bar, iron pipe, or some fight, or something of that kind may be lying on the spot, which the accused left at the time of making flee from the spot. You may find blood oozing from the injuries of the injured person or deceased person. You may find a flood of blood over there. And that is the evidence. Police officer will collect that evidence. Now law says, new BNSS says, that every panchanama in respect of criminal trial, criminal investigation, has to be videographed by the officer who is carrying out that panchanama. Then officer may have a vision that he did not leave the sword, he did not leave the knife, dagger. He has taken it along with him while fleeing from the spot of offense. He must have hidden, he must have concealed that weapon somewhere. So section 23 BNSS, old section 27, not BNSS, I am sorry, Evidence Act and Bharatiya Sakshya Sanhita now 2023, that will come into play, section 23. That accused voluntarily says to the investigating officer that he will show the place where he has concealed the weapon. It may be his house, something behind his house, maybe in the bushes, maybe in the jungle. Wherever he has concealed, hidden that weapon out of fear, the officer will record his statement, which is called as a memorandum statement, which is recorded in the police station. Upon interrogating the accused, after his arrest, he must be in a custody. Then officer has a vision without touching his body. D.K. Basu versus State of Bihar, West Bengal. D.K. Basu versus State of West Bengal says that officer has no right to apply third degree methods while interrogating the accused person. His person must be medically examined before his arrest and after every 48 hours while he is in a police custody. So he will intelligently lead him to make a statement, voluntary statement. The word voluntary is very important. Who will say, sir, I'll show the place where I have concealed the weapon, my stained clothes. In case of cheating, forgery of valuable security, these documentary offences, he may lead the police officer to the place where forged document he has kept in the bank locker, in his own cupboard, in his house, the keys of which are lying in his pocket. So the officer doesn't know where he has concealed, where he has hidden. Officer will say, come on, show. And the law says, this process will have to be supported by two independent witnesses who will be examined in the court of law as a discovery panchas. Some documents may be tendered by the family, brother, sister, father of the accused. Sir, this is the document. Don't trouble him. All right. Some car was used, some motorcycle was used for committing the offense. Somebody may produce the car. Sir, this is the car. As you say, we have produced this car. The Panchanama is prepared. What is called the articles collected during the investigation is Muddemal articles. Muddemal articles. These Muddemal articles will be forwarded to the Forensic Science Laboratory, FSL, Forensic Science Laboratory, where the chemical analyst will examine them from the point of view of collecting incriminating evidence, particularly blood, if it matches with the blood of the accused, if it matches with the blood of the victim, injured or deceased. So these articles will be examined by the laboratory. They will send the report, and those reports are called as a chemical analysis report, CAR. They are called as chemical analysis report, CAR. Other wing of the investigation and the contents of charge sheet, Panchanama in respect of house search of the accused. An investigating officer may search his house, whether he is present or absent, is absconding. He has authority to search the house under BNSS 23, and he will prepare a Panchanama along with video, audio, electronic means. That is a compulsion made by the BNSS and our BSA, Bharatiya Sakshya Sanhita 2023. They provide protection to the accused persons. They avoid manipulation, plantation, mischief that is likely to be played by the police officer, because everything is seen in the video, audio, electronic means, that clip. And that is required to be forwarded to some authorities like district magistrate or the judicial magistrate within 48 hours of the completion of Panchanama. So there is a check on investigating agency. If he proposes to implicate somebody falsely at the influence of complainant, that check is there. Whether the article was really found out from the house, whether the weapon was really found out from the accused under section 23 of BNSS. Then friends, there are two medical documents which are called as medico-legal certificate, MLC. MLC. Normally, the victim is taken initially to the government hospital. Law says they are independent of police. They are independent of accused. They have nothing to do. They have to do their job. And second aspect is, law says they are experts. They know the medical jurisprudence, toxicology. They have full knowledge of law, medical law, jurisprudence. So they are independent witnesses. MLC, in respect of injured person, his treatment papers, and in case of the deceased person, somebody has died, an autopsy, post-mortem, Marathi we call Shavavichhedan, Chirfad. Autopsy is done by the medical officer in the government hospital only. Autopsy is not being performed in a private hospital, they avoid it. So autopsy is conducted just to find out the probable cause of death. Probable cause of death. Last column on post-mortem notes. So MLC and post-mortem notes. How do I know what is written? And doctor's handwriting, you know. You can't read. Better you have a friendship with some good doctor in the city, in your area, whom you can contact any time, either on phone or physically visiting of his dispensary or hospital, who can guide you as to what is to be cross-examined, what cross-examination is to be performed, as to the medical officer on medico-legal certificate, treatment papers, and the PM notes. Brothers and sisters, many a times a dead body is found after 1 year. Man has died 1 year back. A fire is there. And the body was lying in the gutter. The gutter that leads to the ocean, Arabic Sea. And it was stuck up. Those workers who got down into the gutter, big gutter it was, they came across a human skeleton. They brought it out. And the police came. Police thought it may be he who was allegedly reported dead, whose body was missing. So there is a report of histopathology. It will decide, histopathological examination, that will decide whether the skeleton, the bones, supposing the body is burnt and only pieces of bones are lying at the spot. Histopathology report will determine whether the disease, the skeleton, is of male or female or a child. And it will also decide, give an idea as to whether the person died was below 20, between 20 and 30 years, 30 and 40 years, 40 and 50 years, 60 years. What was his age? Then there is a concept of DNA which has developed during last 10 years. After Nirbhaya case in Delhi, Supreme Court said that DNA analysis report is 100% correct examination. 100% correct examination. Genes of that person are collected from hair, from the mouth saliva, we spit, from the blood, from the nails, from the bones, bone of any part of body, even burnt one. And they are compared with his biological parents, his original mother and father. So DNA report, it is a big science. But if you click on the software, you will come across 10, 20 kind of citations by Bombay High Court, by the Honorable Supreme Court. And you must study at least one judgment out of it, so that you understand as to what is the DNA science. Then friends, we are in the modern age. We use the telephone, mobile phone, to send ugly messages to the woman who has gone to the police station and lodged a FIR. Ugly chats, even if he has removed, they can be retrieved, brought back again on the record by sending the telephone to the laboratory. So that is a electronic evidence. Then CCTV footage. Some areas are covered with CCTV footage. The maramari, the fight, the offense has taken place just before the two cameras lying, and everything is recorded in that CCTV. That is the best evidence, provided it is supported by the certificate of the person who maintains that CCTV cameras and the system, DVR, etc., and the person who collected the evidence from that DDR in pen drive or CD and presented to the court with his certificate. There are many challenges, there are judgments on that. So this kind of electronic evidence, CA report, DNA report, histopathology report, all these reports you will have to study carefully. And supposing you don't understand, go to the expert. Don't feel ashamed consulting your seniors, consulting some good doctor, consulting good scientist who is known to you. Meghalaya, there is one scientist, you can go to him. Sir, I want to learn from you. If you spare few time for me, he will guide you, which you may use while cross-examining the witness, putting your case before the court. Friends, what other things consist in it is a test identification parade. See the every content in the charge sheet. There is a judgment you will find from various High Court, Supreme Court. There are a lot of judgments on each of the points. Question is whether you are ready to go to the citation software, whatever they may be. All India Reporter, Crimes, Criminal Law Journal. We have loveliest software of all Maharashtra criminal. Very comprehensive, beautiful head notes. And the lawyer can understand and make understand the judge also, that this is what the ratio lying in that judgment. Question is, you must be ready to read. You must be able to study. To my opinion, lawyer is not supposed to do anything else than his advocacy. Attending courts, attending his office. Then friends, further, you may come across a dying declaration. Two kind of dying declaration. We call it DD. One may be oral dying declaration. The man after the incident in an injured condition is being shifted to the hospital. And somebody, his sympathizer, asks, Dada, ye kaise ho gaya aapko? Dada yani bhaiya. So he discloses, A came with a dagger and he mounted assault on me. He has caused me 4 injuries. Man is taken to the hospital and during medical treatment, he expired, died off. He succumbed to the injuries sustained to him. That is oral dying declaration. While in ambulance, he couldn't record. And after having gone to the, hospital during treatment, the police officer arranges an executive magistrate, a revenue officer. He will invite him to the hospital to record the statement of person who is on the verge of death. The morality appreciated by the superior court says, man on the verge of death will never speak lie. I don't know how much truth lies in it. So that is recorded in writing. So dying declaration in writing or oral. Both, what Supreme Court says, these dying declarations must be unalloyed truth. Sparkling truth. If there is a whisper of doubt about the status of the injured, whether he was mentally and physically stable, whether he was in a position to speak, whether he was in a position to comprehend the question properly and to give answer rationally, if it passes the test, dying declaration, only dying declaration can be relied upon to base the conviction of the accused. But it has to pass. Number of judgments are there on dying declaration. It must be, law says, Superior Court says, it must be unalloyed truth. Somebody has committed an offense, gone home, he came across his cousin. Arey, why you are so terrified? Why you are hopping? He said, I am sorry, मैंने उसको चाकू मारा है. And that cousin brother goes to the police station where FIR has been already lodged. And cousin brother says, sir, so and so accused happens to be my cousin, but unfortunately, I learned from his mouth, horse's mouth, that he has committed this cognizable offense. That becomes extrajudicial confession. It is not before the judge. It is not before the judge. So it is extrajudicial confession, EJC. And there are judicial confessions under section old 164(5) and now 183 BNSS. Magistrate has a responsibility to record statement of witnesses. I told about it to you. But magistrate is also called upon, requested, that sir, he has confessed before us and he is ready to confess before you. Magistrate may record his confession on paper, put it in the envelope, seal it, send it to the police, which will form a part of charge sheet that is filed in the court of law. Now this confession also, judicial confession or extrajudicial confession, your intelligence, whether to make it unreliable or whether to relax and allow the court to pass any order. Your intelligence, your hard work, your study, your reading of citations and collecting the data for your cross-examination, how you prepare yourself. So judicial confession and before that JD and extrajudicial confession. JD and last seen together, you may jot down. LST, last seen together. Accused and the deceased. They were seen walking out of the village and the shopkeeper saw them going out of the village together chit-chatting, and he found after an hour the accused came back and he was looking here and there whether somebody has seen him. And when shopkeeper wished him, Dada Namaste, He didn't say anything. He hurriedly went away to his house. That is the evidence of last seen together. Law says it is a weak piece of evidence. Police may very easily create that evidence, introduce the witness as a got-up witness, and say, you say accordingly in the statement and in the court. We want to convict him. Police may play that mischief. Friends, as to the telephone communication, supposing some 2-3 accused are hatching conspiracy on phone, they had one has called to the other, and the first one has taken third person online, and they chit-chatted. This record can be taken out from their respective mobile phones seized during the investigation. That is called CDR. Call detail reports. Police can find out location of the witness. Even if somebody has switched off his mobile phone, the location science is so advanced with the police nowadays. If he has hidden himself in a jungle, police can go exactly approach him, catch him, arrest him, and bring him to the books. So call details record, SDR, and then friends, as like medico-legal certificate and PM notes, there are some other experts, handwriting expert, fingerprint experts, and footprint experts. He committed murder, he fled away. But his legs' prints are lying on the blood and the dust. They can be technically lifted up by the chemical analyst team of the police. There is a technique how to collect that evidence. Fingerprints and footprints. As to the footprints, permission of the learned magistrate is necessary for taking the footprint for comparison of the accused upon his arrest. Because they may tactfully do anything. Our police are not Scotland Yard police. Your police people and Maharashtra, they wear khaki vardi, they have same tendency. So this is what it contains in the charge sheet. Now friends, another hint to you is whether the offense is serious, whether the offense is small one, always interact with your client, the accused. Talk to him. Allow him to talk on the incident. You will come across the truth called taking instructions from the accused. Very important. You won't say, I have read your charge sheet, I will conduct the case. Go home. Why you are sitting there? Pay fees and get out. No. You must talk to him. Not only talk, allow him to talk. Don't ask him anything. Now we are seasoned lawyers. When the accused come to us, yes, क्या हुआ? तो बोले साहब मैंने और इसमें मारा है उसको, ये दो नहीं थे, किधर थे मालूम भी नहीं. They confess. But to the junior lawyers they may not. They may try to fool you, mislead you. It is your intelligence how to make them talk on the incident and tell you the truth, what has happened there. The law says he is supposed to be he is presumed to be innocent, and the burden is on the prosecution to prove the guilt of the accused beyond all reasonable doubts. Our senior brother Jayanta Zaibhave will speak on elaboration on this topic. But burden is there on the police. Accused can sit comfortably in the court. He has not to say anything. He has not to deny also. There has to be denial. But if he chooses not to deny the case, his advocate or he, so have an interaction with the accused person, so that you know actually what has happened. अरे दोनों ने ही मारा है सिर्फ, और ये दो बोले साहब वो घर पे थे, हम गांव के बाहर थे, हम ये नाका पे थे, ये अपने स्कूल में गए थे, अपने कॉलेज में गए थे, काम पे गए थे. So you can know that prosecution, the complainant and his witnesses have falsely implicated these two innocent persons. And mind it well, my friends, all over-implicated cases have ended into acquittal. Because the prosecution is called upon by the law to prove their case beyond all reasonable doubts. Only two injuries. 2 weapons were recovered from these two, first two, and nothing recovered from them. No incriminating evidence was found against them. Only witnesses that they were present and they were beaten. So friends, talk to your client. If he is in custody, well, talk to him with the permission of the court, in the corridor of the court. Sit along with him on the chair. Talk to him nicely. Get all instructions from him. There was an allegation against a father of rape committed by him on his 3 daughters. And the court assigned me the case as an amicus curiae. He said, Mr. Chavan, you defend this gentleman. Court says him gentleman, because he is presumed to be innocent. I spoke to him, and after speaking to him, I got my defense. The case ended into acquittal. The mother was the complainant and 3 girls, 22, 21 and 18. They were the witnesses, victims. Case ended into acquittal, clean acquittal, not benefit of doubt, because I could talk to them. Second, very important, visit the place, spot of offense. Police draw spot panchanama, police draw kacha map, or policemen ask the revenue officers in Maharashtra to draw the map. How they know? It is none of their business. It is somebody who has got an artistic sense. He can draw the map. This is the road. These are the different houses. These are the shops here. This shop name. Other side there is a Maidan, ground. You have to mention all the things. Where this road leads to 2 sides. Offense has taken place here. Whether CCTV was there. Whether the factum is recorded in the CCTV. But you will have to visit that place. You will have best comprehension of the incident, which you can intelligently use while taking cross-examination, placing your defense before the court. Now, what law says that the learned judge has to presume him innocent. Sometimes, unfortunately, some judges, not all, and this is not my allegation, this is what the factual thing I have seen in my life. Judges get influenced by the contents of the charge sheet. Sometime in the presence of defense advocate, they warn the prosecutor, Mr. Prosecutor, this is a case of conviction. Conduct it properly. I deprecate this conduct. Judge is not supposed to say this, not to bring thought in his mind, because he can't be impartial in that case. He has already cited the case of prosecution and victim. Let's not conduct the case before him. I did that. The prosecutor was instructed in Marathi language, Mr. Prosecutor, this is a case of conviction. Conduct it very properly. I filed application for transfer. You have to be brave. Whether you are paid or not, you must be honest with the charge sheet. You must be honest with the accused. Also you must be honest with the court. Whether it is a court of magistrate, sessions court, wherever you appear, think that it is the Supreme Court for you. You have to respect the court. But to what extent? So long as the court doesn't go unfair with the accused or something of that kind. So know the judge before whom you are trying the case. I have seen the judges in my life, number of judges in our state. Our population is more than 12 crores, Maharashtra. Almost 13 crores. So number of judges I don't want to tell you. Here there are 50 plus judges. Yours is a small state. And because it is small, you could maintain it nicely. If you have come to the Mumbai or some big places, you will see that all disadvantage of being big city are attached to these big cities. Forget that. That is none of our business. Know the judge, whether he is a convicting judge or he is a judge with good appreciation, who makes every endeavor to see that accused is acquitted. And he only convicts when there is no way left to him than to convict him. That should be the tendency of the judge. I have been telling in various programs, passing conviction, convicting the accused is not the job of judge. He has to make a justice. He has to see whether accused is really guilty of the offense or any of the offense alleged against him. You will have to be balanced. So know the judge, also know the PP, police prosecutor or prosecutor working in the sessions court, who is representing the state. Know the PP in not that sense, my brothers. To going, visiting his house, paying in something, bribe. No. Never indulge in this kind of practice. Die today. Work hard. Come out as a good lawyer. And you will find one day you will become the best judge of Shillong Bar, best judge of High Court, best judge of your taluka. Provided you devote yourself. Don't go by corruption. Don't ask somebody's help. Never go to prosecutor. You conduct the case on merits. Now, sir, having done all these things, think deeply as to what is your now defense. What is the probable defense to be put to the witness from the first witness? What could be your defense? In what line you want to take your sessions case to? Think that. Think of alternative defense also. Normally defense is that of denial. That is the best defense. There are number of other defense, I'll talk on that. So friends, think of your defense. Keep in mind, back of your mind, the alternative defense you may propagate while cross-examining the witness. No defense issue, I know, friends, that defense should not be something enchanting. Your defense must be parallel to the prosecution story. Go along with the prosecution story and then deviate intelligently through your cross-examination. Your defense must be comprehensive, convincing, and digestible. Judge must feel that yes, what the learned defense counsel says appears to be correct. Cross-examine the first witness in such a way that the judge will make up his mind, no, I think that this is a false case. and what defense advocate says must be true. You have to begin with first witness. Very, very competitive. You have to, be ready to place your defense, cross-examine the first witness, because that gives first impression in the mind of judge. He starts thinking on that line. So your defense should be parallel, convincing, and digestible. Some odd defense something may be hazardous to your case. So never take extraordinary defense. It must be natural. And the court must go with you. And during cross-examination, I must tell this. While cross-examining the first witness, second witness, panchas, investigating officer, medical officer, allied evidence, whoever they come, try to take your case to the defense you have decided. And then come out with the last suggestion. Then, friends, your defense and your alternative defense, you must justify. You must be able to justify your defense so as to make it convincing, digestible. So always take support of at least 2 good citations in support of your theory. Don't try to search the citation at the time of arguments. When you are preparing your case, find out the citation that will support ratio-wise. Friends, facts in every case, I tell you, they are different than the earlier one. It is a novel-like, it is a storybook, some hero, some villain, some side heroes, some side heroines, somebody, comedian. It is just like movie. It is just like novel, story. So you read with all interest and then support your defense by the citations. Now, friends, the other topic I am given, I'll talk on that for another 20 minutes and I'll conclude my lecture. And we 3 will sit here. We'll have good interaction session. Our senior brother and 2 of us will reply every query that is being placed by you to us, to your satisfaction. So you go with full satisfaction that you have really become, you have been boosted up as a defense lawyer, whether for state as a legal aid or whether for your independent practice. So friends, I'll now tell you the broad defenses available in a criminal trial. The first one is right of private defense. Private is me, my person, my body, my sharir, and my property. Maybe my wife, my children, my father, my mother. Right of private defense. I'll give you a small example. Right of private defense theory, when you decide to propagate during your cross-examination, you must be very careful. Because the charge sheet will remain aside, but now you have come out with your own defense. Although you are not called upon to prove your defense beyond all reasonable doubts, But your right of private defense must be convincing. Just I'll drink the water. You are enjoying? Not boring, no? Yes. Friends, right of private defense, I said I will give you an example. One of the advocate of about, say, 15 years standing, he was practicing on civil side, he never knew probably that what is the right of private defense. He must have not conducted any criminal case in his life. Sleeping on the first floor of his house with his wife and children, and on the bedroom in the ground floor, there is a hall, kitchen, and storeroom, and one bedroom. His old parents were sleeping. They must be aged 70, 68, mother and father. And in the midnight by 1 p.m., he heard the commotion. He heard the noise of his mother crying, his father shouting. And he came out of his bedroom and could see below down in the hall his mother and father as being hammered with the sickle, a big weapon for cutting wood. He went back in the bedroom. He opened the cupboard, took out the gun, and from above he fired on 2 of them. And they died on the spot. Other person fled away because he was not hit by the bullet. And one who was standing on the door to see if somebody is coming, he also fled away. See idiotic conduct of the police. Crime was lodged against them for dacoity. Well, that is correct. Wisdom of police is to implicate our brother advocate in the case of 302, now 103, that he has committed murder. We, the team of leaders of the bar, went to the commissioner of police and told him that is he supposed to come down without arm when he has a licensed gun with him and to become target of the dacoits? Exonerate him from this, otherwise we will move the Honorable High Court of Bombay. Then after a lot of deliberation, police succumbed. They said it is wrong to implicate him. You will understand from this example what is right of private defense. You understand? My life, my mother's life and father's life, father died and mother is alive till today. Although she was injured, she was treated well in a good hospital. But father died on the spot. He had a hammer here. His skull was broken, brain was damaged. Father died. So to save his mother, save his father, he fired 2 shots from above. And he was supposed to load the another bullet in it. But meantime, the third one escaped, and the fourth one, who was standing on the road, they broke open the door of the bungalow, entered inside, and they were asking for the keys of the cupboard where the jewelry and cash amount is lying. So the gentleman was lastly exonerated. Another defense is of insanity. Mad. A mad person doesn't understand as to what he is doing. Mad person is walking on the street He picked up stone and threw on the lady, which hit on her forehead. She was taken to the hospital. She was hospitalized for 1 month. She had a fracture here. Case was filed against that mad person. But the defense lawyer could prove that he is under medical treatment. The family don't allow him to go out. But on the day of incident, anyhow, he escaped from the backside. He came on the street. He was doing his normal idiotic activities. He picked up stone and thrown, which hit here. Frontal bone here, frontal bone. It was fractured. She was on the verge of death but saved. So insanity, again, the defense has to prove. There is a concept of preponderance of probability. The judge must feel that yes, this is a probable thing, what is being propagated by the defense. Judge must be satisfied. He is really insane. A sane person like you and me cannot take the defense, sir, I was mad that day. Not allowed. Your medical officer, especially mental hospital doctor, or some psychiatrist, or some psychologist, must come under whose treatment that fellow was and must certify, sir, that he is a schizophrenic patient. Schizophrenia. So he may be normal during few hours, but suddenly he may get wild and he may not understand as to what he is doing. Father was sitting in the courtyard of his house, in the garden. The mad son came from behind and he toppled his father from the chair. And the father fell down, he impacted his head on the stone in the garden. The flooring, hard flooring. And there was a fracture of skull. But ultimately it was brought on record that he is a mad fellow. The gate was closed, he was not supposed to go out. But what he did is with his own father was not intentional. You know very well. BNS 2023 says that every offense there has to be an intention. If the act is done without intention, it is not an offense. It is not an offense. Every offense, small or big, or there has to be a motive. Motive especially in case based on circumstantial evidence. Motive is seen. Motive is not the only defense, that I had no motive, but I committed murder. Motive may be a probable defense in support of your case. And when there is an unlawful assembly and the act is done by 5 or more persons, it is seen whether they had a common object. Their assembly was unlawful and they carried a common object and they achieved their target by killing him. Somebody hold him, somebody hammered him, somebody thrown stone on him, somebody kicked him, somebody gave fight on his mouth, and the fellow died because of injuries, various injuries. They must have a common intention. If somebody is standing and saying, "Arey, why you are beating him? Usko chodo, us bichare ne kya kiya hai?" Unlawful assembly is broken. 4 cannot have unlawful assembly. 4 will have common object. 3 into bracket 5 now. BNS. 3 into bracket 5 common intention. Try to understand difference between common intention under 3.5 and common object of unlawful assembly which necessitate 5 or more persons. If 4 persons are there, no common object is required to be seen. So friend, there is yet another defense. I believe it is very difficult to put it on record, place it on record. It is of grave and sudden provocation. Two persons on rival terms came across each other, and the first one abused him on his mother, brother, on his caste. And that gave him sudden provocation, and he gave a fight, hit, whereby he sustained injury, and he was charged for section 223. And if there is a nasal fracture on his nose, he was charged under section 225. Now see new sections of BNS 23. So, had he not abused him so filthily, he would not have provoked. So, only provocation is not enough. The provocation has to be grave, serious, genuine. Grave and sudden provocation, because every man has a brain, and brain, there is a mind. दिल से प्यार करता हूँ, यंग लोग बोलते हैं, करती हूँ, वो दिल से नहीं होता है, दिल का कोई प्यार से सवाल नहीं है. She loves from here, or she hate him from here. All thinkings, all thoughts are stored in this big computer made by the nature. So grave and sudden provocation. He abused today. He went away. नालायक आदमी है. He went away. He met after him 2 days. And then he slapped him, whereby his mandible bone is fractured. The only part of the skull area, head, that moves. These all others doesn't move. This mandible is fractured because of the fight he hammered. So second day, third day, it's not a case of grave and sudden provocation. Spontaneous wildness occurred in his mind, and serious wildness, that anger which resulted, which could not keep a control on his fight to hammer him, is a grave and sudden provocation. Then, friends, there is a burden, there is a defense of alibi. Alibi, that is to say, it was not me. I was not present over there. Again, burden is on you. I told you, the most successful defense, which applies to all cases, is of total denial. But these are the various options. You must think on it. You must decide on it how you are going to propagate your defense. So, alibi. Alibi is again a burden on the accused, that no, sir, I was in my office. This is the document, my muster roll. My thumb on the machine, recorded. I never came out of the office even during lunch hours, even during tea breaks. I was inside from 10 to 5. An incident has taken at 1 p.m. I was not there. He has falsely implicated me. Burden again lies on the accused. But it is a burden not proving the case, your defense, beyond all reasonable doubt. But it is a defense which is said to be plausible, acceptable, which is called as a preponderance of the probabilities. We'll talk in short about the few incidents I'll tell you. There was a case that 6 persons staying in a slum area, Jhopadpatti. There are Jhopadpattis in Maharashtra, Thane, Mumbai, all the big metropolitan cities. Some poor people stay there. And there was some rift. गांव का कोई झगड़ा था. So 6 persons entered his house, his jhopdi, and they assaulted him, was the case. And all the 6 were booked. And the fellow died. Because of the hammer on the vertex of his skull, ताड़ू मराठी में बोलते हैं यहाँ पे. The parietal bone center of parietal, this is parietal bone, and this is the center of parietal bone. There was a one stroke of wooden log here. 6 wooden logs were collected, from each of the accused one. What this showed, that one of them has hammered him, and there was no any other injury on the person of deceased in the post-mortem notes. So one of them is responsible. Now here the prosecution is called upon to prove their case. Whether you prove that it was he, 1, 2, 3, 4, 6 out of them who hammered. And if the prosecution fails, but the man has died, and there is evidence that entered in the house, they were there inside for 10 minutes. When he fell down, they fled away. If this evidence has come on record, all 6 cannot be convicted under section 302 and today's section 103. Because it is not clear as to who assaulted, who is the author of that injury, fatal injury. Friends, one lady was cleaning the, sliding windows of her house, flat, on a 3rd floor. And she put a stool, then some bucket or something, and that ordinary cloth was lying in it. And she was cleaning the glasses, and there was no grill. She could not control her body, she fell down from there. Her maternal people, her brother, father, mother, they alleged that she was thrown down on the septic tank below, on the ground floor, where she impacted her head. It was broken, and because of that she died, and these people have thrown. When the Panchanama was drawn, it was mentioned that there is a small bucket. One duster was lying in it, cloth, other duster was falling down. And there is no evidence that they had some intention to kill her husband, or relatives of the husband. You will have to see how you place your defense. You can make this defense probable that she was cleaning the sliding window glasses. While reaching that particular glass, she could not control her person and she fell down accidentally. All accidents are accidents. They doesn't contain an intention. So friends, on this line, I believe you have understood the things, and I again thank you, Honorable Ladyship, all the High Court officers, all the Honorable Judges of the High Court, your Judicial Academy, and all the officers of the High Court, protocol people. Thank you very much. Jai Hind. Yes, sir.
Thank you very much, sir. Can we give him one more round of applause, please? May I now kindly request Lawaka Kanjing Madam to kindly felicitate our eminent resource person.
You have been felicited yesterday.
No, one more time, sir. Thank you. Maybe we can take a couple of minutes if anyone has questions. So we can
We'll take all questions
together.
at the end of
Absolutely, sir.
the 3 lectures.
All right. If that's agreeable to the other resource persons also, please. Okay, thank you. Thank you, sir.
Let us call Rajan sir now.
Okay. Thank you, sir. May I now request the Joint Registrar and Officer on Special Duty to the Honorable Chief Justice's Secretariat, Shri B.M. Sangma, sir, to kindly escort Rajan Salonki, sir, to the dais. Sir, like the earlier resource person, is also an advocate with 28 years of experience. He comes from the renowned chamber of late Chandrakant Babar Desai, from his chamber, and he's also one of the resource persons for today. Sir is an accomplished lawyer specializing in trial advocacy. He is a recipient of prestigious awards, and he is also a seasoned speaker, author, and educator. Since we have a little bit of time today, I'll just take a few minutes to give a befitting description of Sir. Sir is a current member of the Bar Council of Maharashtra and Goa, having his practice of over 28 years since the year 1998. He is the founder of the RS the law firm, specializing in trial advocacy, and is also known for handling complex and high-profile cases. Sir is a recipient of the iconic Legal Advisor for Real Estate Award presented by the Midday Real Estate for his outstanding contributions to the legal profession. Sir is a seasoned speaker, delivering lectures in continuing legal education, CLEP, organized by the Bar Council of Maharashtra and Goa. He has participated in the preparation of the Handbook for Civil and Criminal Practice Manuals for the Bar Council of Maharashtra and Goa. Sir, as he has been invited here, has also been invited by various bar associations and legal forums on topics ranging from criminal law, professional ethics to legal education. I think it is befitting that Sir would be taking the topics that has been assigned to him today. The second session that we will move on to next are on the art of cross-examination, with special focus on denials, omissions, contradictions, and suggestions, available defenses under the law, Section 23 of the BSA 2023, corresponding to Section 27 of the Indian Evidence Act, overview and application of discovery evidence leading to seizure and recovery of weapons. With this, I give the time to Sir. So whenever you're comfortable, you can take the time, please. Thank you.
Good morning. Now you have already heard the Sir. This is first time I have came out of state of Maharashtra, so bear with me. My endeavor during discussion is that to point out exact provisions of BNS, BSA or BNSS which we use during the course of criminal trial. We all know that we cross-examine or prosecutors lead evidence on the point of spot panchanama, which is part and parcel of each and every case. You cross-examine those panchas, witnesses, and able to prove that spot panchanama is a false panchanama, and sometimes secured acquittal or get conviction or whatever it may be. My endeavor is to point out those provisions under which the public prosecutor proves spot panchanama, and under the provision by which you are cross-examining the witnesses, exact provision where it is lying. Once you know how prosecution is proving it with the help of evidence, will be more efficiently able to cross-examine them. So my endeavor is to point out those exact provisions of those three laws which we are using during our daily practice or trial in the court. Topic assigned to me is relating to, just let me get comfortable with it. Yes. So these are the four topics, since the entire trial can't be discussed in a short while. These are the four topics which we are going to discuss, or we see relevant provisions of this in the all three main acts. Now, since we are a defense lawyers, our endeavor is to see that a clean acquittal is taken, or in tough cases will try to reduce the punishment or go for a probation. That is our object. Now, while dealing with these preparations, we must know what are the kind of witnesses which we came across during the trial. So, these are the types of witnesses. Now, Chavan sir has already informed how to read the charge sheet, how to, thank you sir, segregate the witnesses like eyewitnesses, partisan witnesses, that is interested witnesses, or the bypassers, or the persons who are naturally present on the spot. These are the witnesses which we need to cross-examine. Second are the different panchanamas like inquest panchanama, spot panchanama, arrest panchanama, or the section 23, that is discovery panchanama. These are the panch witnesses, supposed to be an independent witnesses. We have to cross this set of witnesses. Then there are experts like doctors or the forensics experts. Then the digital evidence. Nowadays, digital evidence is a mandate during the investigation. So we have to be expertise with those provisions of the BSA. Last one is the dying declaration or the test of identification parade, where we have to cross-examine the magistrates, then the sanctioning authority, and last one is an investigation officer. So there are different set of witnesses, and we need to prepare differently for a different kind of witnesses. So be well versed with the fact as sir has stated. Now Chavan sir has already said that we are entitled for a charge sheet free of cost. As I said, my endeavor is to point out exact provision. Section 230 is the provision which is on the screen. We are entitled for this charge sheet without delay and free of cost. Now sometimes there are voluminous charge sheet, we can get it in the pen drive. Provision is here. So section 230, you are entitled for the entire compilation of the charge sheet. Then section 239, sometimes court frames the charge. The moment charge sheet comes to the court frames the charge, and while after framing of the charge, if court comes to a conclusion that there is need of an alteration of the charge, if the charge is altered, then we are entitled for the new trial or the adjourn the trial if there is a prejudice caused to the accused. So that provision is section 239. Clear? Then in case if new trial or is not possible or not required, we are entitled to recall the witnesses which are already examined by the prosecution. So these are the powers vested with the defense lawyer in case of there is alteration of the trial by the courts for any reason. Now, sir has already said that while preparing defense lawyer is a first person who comes into contact with the accused, and we have to seek information from him. Now this information is a professional communication between a defense lawyer and the accused person. This is protected under section 132 and 134. I have cited one judgment of 2026. You must have read the newspaper or the judgment. In this case, Gujarat police have summoned a defense lawyer along with the accused and required him to share the information what he has taken from the accused. So which will help to gather the evidence to prepare an evidence for their case. Now we being defense lawyer, the accused share so much of information to us relating to the commission of crime. Sometimes even a confession, how he has committed or whatever tampering he has did. Now this communication is protected by section 132 and 134. Suo moto cognizance of this issuing of notice was taken by the Honorable Supreme Court. That's why it is labeled as suo moto writ petition. After going home, I would request all of you to go through this judgment. More than 60 advocates appeared, including Bar Council of India, Supreme Court Bar Association, to protect the rights of advocates, particularly the defense advocates. Because if such system has started, whereby defense lawyer are started summoning by the investigation officer, this will certainly go against Article 14 and 21 of the Constitution and right of the accused under Section 22, that he has right to defend through a counsel of his choice. So this judgment is important to protect our rights, our communication with our clients, the accused who shared some confidential information with us. Now, subclause A, if you could see, there is an exception. If by any means, see, we are defense lawyer, we know how to defend the accused from a crime. But for any reason, if we use this skill to commit a crime, then we are not protected. So keep it in mind, our skill is to defend and not for a commission of a crime. Otherwise, same provision will go against us. So we are not supposed to use our skill for any illegal purposes. Going little ahead, I'll be little fast so that we can go through maximum provisions. There is a separate lecture on this point of Section 351 by my fellow senior. So I won't go much on this about power to examine the accused. But question would come that how to seek information from the accused. Many a times issue comes that how to take information from the accused relating to the crime. As Chavan sir has said, go through the charge sheet, master with the facts, and then start taking information from the accused. Now, how to seek that information from the accused? We all know at the end of evidence led by the prosecution, the next step comes, that is 351, that is 313 earlier. These are the questions asked by the court to the accused after completion of the evidence. Now, do you know what are the questions asked by the court under 313 or 351? There are two fixed questions asked by the court. One, did you heard the evidence recorded in the court? And what you have to say about this? These are the two questions, same thing you have to ask to the accused. This is, I am talking about developing communication skill with your client. How to seek information. Whatever you have gone through the charge sheet, explain him and seek his explanation. Then the last four questions asked under 351 to the accused. What you have to say about the entire charge sheet? Do you want to lead any evidence? Do you have any witness to the case? So these are the same questions which are asked by the courts at the end of trial. What I am requiring you or telling you to develop your communication skill with the accused, you must ask these questions while seeking information. Then he will start talking. If you ask him about some panchanamas, he may say that these panchas are connected with the complainant. Now this could give you a lead to the cross-examination. Sometimes he says that weapon shown by the police is not the actual weapon, because he must have dealt with that weapons in whatever way. So that weapon is different. So this is a lead by the accused to a defense counsel. Now, this is the way you have to develop the communication skill with your client while seeking information. So first one, you read with the charge sheet. Second, you develop the skill while seeking information from the client. Now this skill or this communication is protected. Going little ahead, these are the 4 cardinal principles when you proceed with the trial. We all know this. Just bear it in the mind throughout that there is a presumption of innocence. It is a prosecution to prove the case beyond all reasonable doubt. And the defense of the accused is only to the extent of preponderance of probability. Now, since there are students also participating in this, do you understand the word preponderance of probability? The burden of the prosecution is to prove the case beyond all reasonable doubt, whereas burden on the accused is just to bring a probable defense. The moment we show that the defense brought by the accused is just a probable, it is not that hard burden as it is on the prosecution. It is because of these 4 cardinal principles, the conviction rate is around say 5 to 10%. So being a defense lawyer, we must use this skill or these cardinal principles in our mind. Now, these principles, if you see collectively, then our judicial system or the criminal jurisprudence says the accused is not convicted on the basis of the charge sheet, but he is convicted on the basis whether it is proved or disproved in the court. So, proving of the fact becomes a very essential part of the trial. Now, proving is dealt by the provisions of Evidence Act or the Bharatiya Saksha Adhiniyam. So, while going for the trial, what is expected that you must marshal or master with the provisions of BSA. Now, it is not possible to discuss all the provisions of the BSA, but I'll try to point out few important provisions of BSA. Now, many a times we see that it is difficult to read and understand Evidence Act because the language used in the Evidence Act is bit different and difficult. After studying so much of sections, I have carved out 9 magical words. If you could understand the meaning of those 9 magical words, it will be a easiest way to understand the Evidence Act. Out of those 9 magical words, 3 are on the screen. Fact, fact in issue, and relevant fact. Now, this is what expected from a prosecution or the person who is asserting in the court to prove. What is fact? That is defined over there. It is state of thing. State of thing means what? Spot Panchanama. Under spot Panchanama, what we do? The prosecution try to bring that, look, this is a spot, blood is found there, some wooden logs are found, or some clothes of the deceased or the injured are shown to the persons during the evidence. So these are the state of things. Then second part, capable of being perceived by senses. Senses, there are 5 senses. One is eye, ear, nose, taste, and touch. These are the evidence led by the prosecution. As I stated at the beginning, my endeavor is to point out those sections by which it is done by the prosecution. We all know that this is the way prosecution proves the case. Spot panchanama, eyewitnesses, the article seized in the crime, and etc. I am trying to point out these are the provisions under which they laid the evidence. So section 2F is a fact. Then section 2F subclause 2 is a mental condition, motive to the crime, intention to the crime. Where it is written? Section 2F. Clear? Fact is clear? We'll go to fact in issue. Fact in issue is what? It is a thing which is asserted or denied. Asserted by whom? The person who approaches to the court, prosecution. Now prosecution comes to the court with case asserted. Asserted means what? A committed a murder. So court frames the charge whether prosecution prove that A has committed murder of B. This is fact in issue. Clear? Fact in issue is, in a simple language, is a charge which is framed by the court, or the issues which are framed in the civil case. That is fact in issue, whereby existence or non-existence are proved. Clear? We will go to the third word, that is relevant fact. Now what is relevant fact? Relevant fact are those facts used to prove fact in issue. Let us understand in a simple way. Spot panchanama, blood is lying on the spot, some weapons are lying, then clothes of the injured or the deceased, then the weapon discovered from the accused, then the eyewitnesses, then the circumstantial witnesses. Now what prosecution or the prosecutor does? He brings all those pieces together and says, fact in issue is proved. Fact in issue is what? A committed murder of B. And what prosecutor is doing? He is bringing pieces of evidence. In our younger days, we know there is some game, we bring some kind of pieces and bring them together and try to make one image or a frame. Now these pieces, small pieces, is a relevant fact. If you could remember these three words, you will able to understand the language of Evidence Act. Because they don't use a simple language, they use the language fact in issue and relevant fact. Concept of fact, fact in issue and relevant fact is clear? Three words are clear? We'll go to the next three magical words. Proved, disproved and not proved. I have quoted those sections where the words where it is defined, 2J, 2C and 2I. Now proved means what? It is a positive assertion. Existence is proved. Disproved, where non-existence is proved. Chavan sir has just said that we can take a defense of alibi. Alibi means what? The accused was not present at the spot and he has not committed a murder. So what we are proving? We are proving non-existence. Try to understand two words which are inside these provisions. That is existence and non-existence. And last one is not proved. Means the fact there are few things which prosecutor do not choose to prove. And neither the defense takes any steps either to prove or to disprove. So these are the next three magical words. Have you watched new movie on Amazon? Some Sonakshi Sinha has acted. A daughter and a son fight is there. And apart from a movie, the main theme in that movie, I think System is the name, they fight on the basis that whether you commit a crime or not is not an issue. But whether you able to prove it or not is the main criteria. So, proved, disproved and not proved. Disproved is done by the defense lawyers. We try to falsify the evidence brought by the prosecution. So these are the three next words which you have to remember. If you could remember this, it is easy to understand the Evidence Act. I'll read only 2 sections thereafter, how to read Evidence Act even. Then these are the presumptions used in the Evidence Act: may presume, shall presume, and the conclusive proof. There are many presumptions under Evidence Act. May gives a discretion. Shall is a mandatory presumption for the courts. And conclusive proof, where there is no scope to either side, it will be presumed to be true. So if you could understand these 9 words: fact, fact in issue, relevant fact, then proved, disproved, not proved. Last one, may presume, shall presume, and conclusive. Clear? If you could read these 9 words, by heart them, understand them, then you will able to understand Evidence Act in its entirely. Otherwise, it is really difficult to read Evidence Act and to understand it. Now, these are the 3 sections I'll read just to understand how to read Evidence Act. Now, section 3 deals with evidence may be given in suit or proceeding of the existence or non-existence of every fact in issue. Fact in issue, you understood? The charge framed. And of such other facts as are hereinafter declared to be relevant, and of no others. Have you came across the judges whereby they object you to the questions? They say that disallowed. Now, many a times I used to say, why you are disallowing? Let me ask. After reading this section, whether it is correct or not, will come to a little later. But the judicial officers refuse to the question because section 3 says you cannot lead evidence which is not in fact in issue or a relevant fact. Because it specifically says, and of no others. Now, whether it is correct or not is a different issue. But this is the provision entitles the judicial officers to say no. No to the question. Now, the moment he says no to the question, our job is to bring that question in fact in issue or relevant fact. If you are able to prove that the said question is related to fact in issue or the relevant fact, then you are entitled. So it's a debate. My endeavor is to point out the section under which we are fighting. Many a times we do this kind of a fight. If we win even in some times. But it is section 3 where this fight is disclosed or explained. Clear? Then coming to section 4, relevancy of facts. Facts which, though not in issue means not in fact in issue, are so connected with the fact in issue, means they are connected with fact in issue, or the relevant fact as to form of same transaction are relevant whether they occurred at the same time and place or at a different times and places. This is what I was trying to explain in relevant fact. So, while proving a murder, the prosecution tries to bring out evidence of different time and places, bringing them together, connecting with each other, and trying to prove fact in issue. Where this attempt is explained under section 4. Then last section we'll read, that is section 5. Now, while reading this section, keep it in mind, spot panchanama. In every case, we see the spot panchanama. Fact which are the occasion, cause, or effect, immediate or otherwise, of relevant fact. Relevant fact what? At a particular place, A and B had fighted with each other. And during that fight, A committed murder of B and some blood stain is lying on the spot. Now read again that first line. Fact which are occasion, cause or effect of relevant fact. Understood? Of fact in issue which constitute state of things under which they happened. When that fight has took place between them and something had happened, so that has been worded here, or which afforded an opportunity for their occurrence. By showing that blood, what prosecutor is trying to prove? That incident has occurred. That blood shows the occurrence of that transaction and they are relevant. So, by reading this section 5, I am trying to explain how the Bharatiya Saksha Adhiniyam is used in actual trial. By using same method, you can go through other sections. Section 23 and section 148 I'll deal. Rest of the sections, I would request you, all of you, to understand those 9 magical words, read and understand fact in issue and relevant fact, and try to understand those sections. So that will help you to understand Evidence Act or the Bharatiya Saksha Adhiniyam and its use, real-time use during the trial. Clear? Now with this, we'll jump to the main topic, that is contradiction and omissions. Now contradiction and omission, since there are students and new lawyers are there, I would request to bear the seniors with me because I'll have to go with the basic concept to understand what do you mean by contradiction and omissions. What is contradiction and omissions? You understood? Or you know that? In charge sheet, statements are recorded by the police. Now these statements we study properly in detail. These sections are recorded as per section 180 of BNSS. I have not quoted that on the screen. It is 180 of BNSS. Now while that is earlier 161. While recording that statement, there is exceptions or there are procedural calls how that statement should not be recorded or how there is a bar to section 161 or 180. That is 181. 181 says no statement made by the accused to the police officer in the course of investigation under this chapter shall, if reduced to writing, be signed. Let us read, no statement shall be signed. So therefore you see, except FIR, rest of the statements are unsigned. It is because of this. Then it says, nor shall any such statement or any record thereof, whether in police diary or otherwise, or any part of such statement or record, be used for any purpose. Means what? Shall not be used for any purpose. So statement recorded by the police is of no use for any purpose. Am I clear? Now, after that comma, be used for any purpose is very important. Save hereinafter provided. So, that statement recorded by the police is useless. Except this. What is? At any inquiry or trial in respect of offense under investigation at the time when such statement was made, provided that when any witness is called for the prosecution in such inquiry or trial whose statement has been reduced into writing as aforesaid, any part of his statement, if duly proved, underline this, if duly proved, a witness is coming in the witness box, he is saying something, now prosecutor is barred from using his statement, he leads some evidence, out of when he laid that evidence, if something is duly proved, only that portion will be used, may be used by accused. So who is supposed to be entitled to use that statement? Only accused. And with the permission of the court by prosecution to contradict such witness in the manner provided by section 148 of BSA. We are right now just understand the relevance of statement recorded by the police. Statement recorded by the police under section 180. 181 says it is of no use to the prosecution for any purpose. Then the saving clause says it can be used by the accused to contradict with the permission of court. And only if it is duly proved, then only accused is entitled to it. Now how to prove it is in section 148 of Bharatiya Sakshya Adhiniyam. Clear? Now same section explanation we have to see. An omission. Many a times it is asked to me to explain contradiction and omission. Before explaining that, I am trying to tell you where it is written, where it is in the BNSS. So it is section 181 which deals with those two words, contradiction and omission. So first understand section, then we'll see how to use it. Clear? Omission is what? To state a fact or circumstances in the statement referred in subsection 1 may amount to contradiction if the same appears to be significant and otherwise. Many a times a question is going to come from your side that when omission amounts to contradiction. Omission means what? In a simple word, sometimes witness during his examination in chief says something which he has not stated in his statement under 180. In police charge sheet there are statements, and while leading evidence he makes some improvements which are not part of his statement. That is called omission. Now whether each and every omission is contradiction or not, that is answered in this section. If he says कि my age is 56, my mobile number is so and so during evidence, and his mobile number is not a part of the charge sheet or the statement, whether that will amount to contradiction? No, if it is not relevant. It is just an explanation which is not forming part of the statement, but it is not having any impact with relevant fact, or it is not having an impact with the fact in issue. If that is so, then it is not of, it won't be treated as an contradiction. But if it is something significant, in the statement he says that A was holding a revolver, and by that revolver he has fired on B. And in the evidence he says no, there was no firing at all, and a sword was used to assault. Now this is totally in conflict, and it is a significant to the fact in issue. Why I am using word significant to the fact in issue? I don't want you to use word all the time murder and everything. To understand the word fact in issue. Fact in issue was A committed murder or B or not. So if the omission is significant, then only it will amount to contradiction and can be used, not the minor contradiction. This is an explanation to various judgments on the point of contradiction and omission. Did you understand section 181? Exact definition and how to read. Just to make it more easy, I have highlighted it with yellow and red, so that you should know where to stop and where to again restart the section. Now this deals with section 148 of BSA. What it says? 181. It can be proved subject to provisions of section 148. So proving it, or the procedural part, how to prove. Now you understood that there is something stated in the statement and in the evidence he has stated something else. Now this is a contradiction and omission, which is one of the best weapon in the hands of defense lawyer, which is explained in section 181. But how to use it, how to bring it on record? Section says, follow provision 148. This is 148. 148 of Bharatiya Saksha Adhiniyam. Now what does it says? A witness may be cross-examined as to previous statement. Previous statement means recorded under 180, read with 181. Made by him in writing or reduced into writing and relevant to matter in question without such writing being shown to him or being proved. I'll explain this in practical way without showing. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it, whether which are to be used for the purpose of contradicting him. Now, contradiction and omission happens in real time. We all defense lawyer are sitting in the court, he laid an evidence, and in real time we see that his examination chief is contradicting with his statement under 180. And in real time we have to be prepared with all these things. While pointing out portion mark to him, we cannot show him that portion directly. That is what stated, without such writing being shown to him. So, while asking questions, while bringing those contradiction and omission, we must know how to ask it, how to bring it on record. So now we have seen 181, 148, which says you cannot confront him directly, go procedure, follow the procedure, and to prove it. And only if you proved, then only it will be read. These are the questions which I have formed. You can form it as per your own skill. But basic understanding is to, while forming those questions, you must read or understand the basic of section 181 BNSS read with 148 BSA. What we have just read. So what did we did? Did the police record your statement during cross-examination or during investigation? As I said, I cannot confront him directly. I cannot show him, look, this is what happened. Okay? I cannot show him directly. I have to ask him whether your statement was recorded. He will say yes or no. If he says no, it is good. If he says yes, go to the second part. If yes, whether your statement was recorded on this particular date. Then, without pointing out the provision, without pointing out that portion, ask him whether have you stated so to the police or whether such thing had happened. The exact portion of his statement under 181, which he has not stated while leading evidence. I am going little slow so that you can understand it properly. There is a statement under 180. There is an evidence in the court which is in direct conflict with his statement. Now I am putting him that whether such thing had happened, which is part and parcel of 181, 180 statement. So I am just pointing out whether such thing had happened. Whether you stated to the police or whether it had happened that accused fired with a revolver. He may say yes or no. After recording that answer, then you are entitled to confront a portion. So this is a way to, then question number 4 is there. Then you bring his attention to that particular portion. That your statement says so. You can't jump directly to question number 4. Why you cannot jump to question number 4 directly? Because 181 read with 148 puts a bar. You cannot point out him that portion directly. Clear? It's a delicate issue. I want you to understand each and every line of this contradiction and omission. You cannot point out to him directly. Now, the moment you point out that particular portion, the whatever answer comes from his mouth, whether he says, yes, I have stated this, or he may say, I have not stated this portion, he may disown that particular part. Request the court to mark it as a portion mark A, B, C, D. This happens when witness turn hostile and prosecutor use this. Even prosecutor can use this to cross-examine or to bring those portion of record. Procedure prescribed is same. This is the same procedure which both have to follow. So only portion mark will be marked as article A, B, C, D, whatever the many a times multiple contradiction and omissions are there. Those portions will be marked. Then you will have to point out those portions to the investigation officer. Again, by following the same procedure, you cannot take him directly to that portion. Ask him whether he has recorded statement of that particular witness. Then ask him whether his statement, this particular portion is forming part of that particular statement or not. The moment he says yes, then that will be exhibited. We all understand the meaning of portion mark ABC and difference in the exhibiting. Exhibiting means what? It is duly proved. Then and then only we can use it in the argument. Then and then only court is bound to take note of it. A layman may say that look, statement is there and his evidence is there. Both the document if clubbed together, when a layman can understand that there is a difference, why not the court? The reason is there is a prescribed procedure to bring contradiction and omission on record. Otherwise, law says the statement under 180 cannot be used for any purpose, either to prove or to disprove or to corroborate. Then there is a privilege to accuse, that accused can use it to contradict. Now, how to contradict? 148, which says how you will have to contradict. Show him his previous statement with his evidence. Can you point out directly that? No, because this puts a bar. You cannot point out him a portion mark. You will have to follow the process. And the moment you follow the process, till you prove it through investigation officer and it gets duly proved, then and then only you can prove or you can read, because this use the word if proved. And after following this procedure, the moment you come to the stage of argument, then the court asks whether the contradiction, omission is minor or significant, or when omission amounts to contradiction. It's a battle between us. My object or purpose is to make you understand where the contradiction and omission are defined, what is the procedure to be followed, and use it while at the time of final argument. Am I clear with this main object, contradiction, omission? You can note down your questions if any you have a query. At the end or the third section, after third session, we can sit together. Now, this is a landmark judgment, 1959 judgment we all know. Would request the all students and new lawyers, please read this judgment in detail. This judgment has defined the word contradiction, omission, and the circumstances when that omission amounts to contradiction. Now, almost more than 70, 80 years lapse, still this judgment is referred and relied upon on all the judgments when the issue of contradiction and omission comes. So, this is a landmark judgment, Tahsildar case. There is some issue with my sequence. With this, we'll go to the second part, or the defenses which are available to the defense lawyer. Now, my learned senior has already dealt with the issue of what are the defenses available to the defense lawyer. They are mainly classified in two types. One is negative defense, one is positive defense. Negative defense is what? What we take in all the cases, that is total denial. Let the court frame the charge in whatever way, we are simply going to say not guilty. By saying not guilty, what we are saying? Prove everything. This is negative defense. It is not defined anywhere. But there are some exceptional defenses where accused admit the act. He says, yes, this act has happened, but it is exempted under Chapter 3 of BNS or the IPC earlier one. Both have same exception chapter. So, Chapter 3 deals with the exceptions. Those exceptions also I have quoted over here. Mistake of fact, necessity, and etc. You can go through it. It is easy to understand. They are forming part and parcel of the BNS. So these are available defenses. Negative defense is not explained anywhere, but positive defenses where accused admit the act, but takes a defense that it is an exception. So this section deals with where accused to some extent admit that act is there. Chavan sir has already explained right of private defense in detail. Now, there are some procedural defenses available to the defense lawyer. What are those? Discharge application, not to go for a trial. If you came across any material defect in the charge sheet where sometimes sanctions are mandated, if those sanctions are not there, you can go for a discharge. Like in anti-corruption cases, Section 19 sanction is there. In Arms Act, sanction is there. So, in case if there is some material legal defect in the case, you can go for a discharge. Or sometimes, at the instance of complainant, victim, some innocent person is also added as an accused. You must have seen in matrimonial matters, a aggrieved woman invokes Section 498A and then arrayed the entire family of the accused, all his married sisters and everybody who are not directly concerned. So if you found that in the charge sheet, she is saying that her sister-in-law is staying in US or UK, but she used to torture through phone or something. Now there is no prima facie evidence in the charge sheet. 498 says, have you read 498A? Go through 498A. It says physical assault, demand of dowry. It does not say a word. This could be a cruelty or humiliating circumstances, but does not fall within ambit of 498A. Now there is a charge sheet which speaks or says about something about the allegations, but it doesn't fit to 498A. There are allegations, but not within ambit of 498A. There is no physical assault. There is no allegation of demand of dowry. So you can go for a discharge by showing that there is no prima facie case against the accused. For framing of charge, prosecution has to prove a prima facie case. So while going for a discharge, you will have to say how there is no prima facie case is made out, and some other technical defenses are there. Now with this, we'll jump to I have forgot one point, that is suggestions and denial. I have not written over there. But what do you mean by suggestions and denial? Suggestion is an opportunity to the accused to explain his case. In short, it is putting our case to the witness, that accused was not present, or you were not present, or the other witnesses were not present. These are the positive assertions from the side of accused, which has relevance with your defense, whatever defense you have taken. So these are do's and don'ts. While putting up those suggestions, put up one fact at a time. Don't put up entire suggestion. If you ask combined suggestions, he is bound to deny. So put up in a short way. So this is the way you should put suggestions and denial, which is also a main part of trial. We have seen fact in issue. Fact in issue, what it says? We'll go back to fact in issue just for understanding. Section 2G. Existence, non-existence, asserted or denial. Why denial is important, you understood? We do it in every case. We say that your case is false. You are telling lie to the court. You filed false charge sheet. What we are doing by that? Denial. And where it is stated? 2G. Clear? So suggestions and denial is also have an importance, and we must all use this. Now with this, I'll jump to the last chapter, that is section 23, or earlier section 27. It deals with the discovery of particular weapon or incriminating article used by the accused at the time of commission of crime. Now, any confession or statement made to the police is not admissible. That we all know. Earlier this was section 25, 26. Now in BSA it is combined, all three has been combined in section 23. That's why I have given the chart. Section 23(1) says no confession made to police officer shall be proved. You understood word shall? May presume, shall presume, conclusive, proved, disproved, not proved. Easy to understand. Shall be proved, a mandatory bar. So no statement will be used. Then section 23 subclause B, no confession made by any person while he is in custody of police. So once he is arrested and is in police custody, if he made some statement relating to the commission of crime, that is not admissible. Now the most important, that is 23 subclause 2, a proviso, which is earlier section 27. This is an exception to earlier sections. This carves out a exception which says, provided that when any fact is deposed to discovered in the consequences of information received. Information received from accused and discovered to the police from a person accused of any offense in custody of police officer, so much of such information. Now this word, though I have not highlighted, kindly note down for yourself that so much of information means what? Only that information. Only so much of information. Whether it amounts to confession or not, as relate distinctly to the fact discovered may be proved. Now read so much of information distinctly to the fact discovered. Now A commits a crime. A committed murder of B by using a weapon, revolver. During investigation, he says that I have hid that revolver where in some bank of river or somewhere. And he confessed the crime. He voluntarily says that I'll show that place and I'll give that, hand over that weapon to the police. After recording the Panchanama, police take that person to that place. He shows that place and discovered that particular weapon to the police, and police seized it. Now, accused has made confession of crime to the police of commission of his act. Whether that can be read? No. Reason 23 proviso says only so much of information which is discovered. So only the part of discovery of that weapon which is brought in the court, only that part will be considered, not the earlier confession, what he has stated to the police. Am I clear? You able to make a distinction between word so much of information distinctly connected to the discovery? So rest of the part will not be considered. So prosecution still carries a burden to prove the motive to the crime, still carries a burden whether said weapon is used or not. Only the weapon, discovery of weapon will be considered. And they will have to omit rest of the part which is incriminating to the accused. Clear? Now this is a landmark judgment which elaborately described the word distinct information. What do you mean by distinct information? You can read this judgment. It's an old judgment, but a landmark judgment. You will find it is referred everywhere. It is of Privy Council, but the word distinctly, the word so much of information is properly explained in this judgment. So once you read the scheme of section 23 with judgment and use it, start using it in the trial, you will be master of section 27 Panchanama. Now how to attack on the Panchanama? What prosecution has to prove? This is a fact which is discovered. It is not known to the police earlier. So try to show that bank of river is a public place, accessible to all. This can't be a discovery. Try to show that panchas to those Panchanama are not independent. They are stock panchas. And sometimes, as I said earlier, accused gives a lead to you that this is not a weapon. Actual weapon is destroyed or somewhere else. Then try to connect those discovered weapon with the medical record or the injuries, whether they are tallying with each other, whether the ballistic report, forensic report tallies with that or not, whether blood grouping on the weapon and the injury or the disease are same or not. So try to connect collectively, prepare your defense in the mind, prepare, go to the extent of citations and then stand for a cross. Your defense is going to remain same till the appellate court. So the appellate court, our fellow lawyers and senior lawyers, should not say that defense has not been properly taken or properly precaution has not been taken. We have a very responsible job because your defense will remain same. It should not be said by the court that I agree with the appellate lawyers, but this defense does not find place in the cross. So we are handicapped. There is a contradiction, we can see it, but only proved contradictions can be used. Trial advocate has not taken pain. So this should not happen. We carry a very responsible job while these are the three other defenses which you should find from the charge sheet. When accused is arrested, human right came into picture. Sir has referred judgment of D.K. Basu. There are some restriction on the police. They have to maintain some registers like lockup registered, handcuff registered, or the vehicles, government vehicles are used in the crime. While taking accused from police station to the spot, they are required to maintain this record. You will find that these documents are not finding part of the charge sheet. In most of the cases, they don't annex these station diaries entries or these extract of register in the charge sheet. Thoroughly study the charge sheet. If your accused is confident and says he never went to the spot, his signature was taken under force or coercion, he never, on the blank paper, he was never been to the spot, this is not a weapon, then be bold and call for these documents. These documents will help you to decide timeline, whether at that particular time the accused was taken, brought out of the jail, out of the police custody, whether vehicle used, is there are corroborative entries in the logbook or not. So if you could use these information properly, if you are able to prove these informations in the court, we can attack on that Panchanama under section 27 earlier or the section 23 Panchanamas latestly done. Now new BNSS puts a provision that while carrying search seizure or while recording statements, this can be done audio or video record through mobile. So now burden is more. There you will have to face those audio or video in the court also. So be well versed with the digital evidence. See that section 64B or section 63 of New Act certificate is annexed. See that whether those videos have been uploaded immediately and sent to the concerned magistrate or not. So while dealing with digital evidence, be clear with those mandates put by the section provisions of BNSS or the Evidence Act. Last one, I'm coming to an end of my lecture. Sometimes accused are convicted. See that he is convicted for less than 3 years. Argue that case doesn't fall under section 307. It is 326 or 324 or sudden provocation, all culpable homicide not amounting to murder. If you could able to bring his conviction below 3 years, trial courts are entitled to grant a bail. That is a section 433. Or you, in case conviction is more than that, appellate court are entitled to grant a bail. This I have already stated. For assuming a situation where you came across a conviction confirmed up to apex court or the highest court, don't give up the case. Still, our BNSS or the earlier CRPC says that convicting a person is not an object of law. Our jurisprudence says person should be reformed, not convicted. He has every opportunity to live his life again, though the guilt is proved till the apex court. So try to bring him in the society. These are the provisions which entitles the governor or the president where some discount is granted, even though he is convicted by the highest court. So, being defense lawyer, don't give up. We are the only person on whom the accused is relying upon. Our Indian law says ignorance of law is no excuse. But our academics, during our academics, whether you are bachelor in arts, commerce or science, we don't have a subject of law. But law says we are presumed to, means ignorance of law is no excuse. Now, if you combine this, one says our citizen cannot take a defense that they are ignorant of law. But they have not taught this in the academics. We are the only person who can educate them. Till the time these provisions are implemented by the state, we carry this responsibility to explain to our client, at least right now. In fact, we take this responsibility to explain to the society at large. Make them aware of law. Explain him his case. The person to whom we are defending or the entire judicial system is formed. It is to form with an object to deliver a justice to a client who is either complainant, victim, or the accused. And you will find at a many places, they are the most ignorant. In many times, they don't have enough place to sit. They don't know the law. And they are fighting in the court with a principle that they cannot say that they are ignorant of law. So take that responsibility. Be diligent with your cases. Be well prepared. We carry heavy burden to the society. Nowadays, even complainant or the victim are also active. They engage private counsels. So they are well prepared. We are facing witnesses who are well prepared. They have been taught, say no to the question, deny the question. So don't put your suggestions directly. Now, if some person is been told that say no to the question, try to break his psychology. Ask him simple questions. Make him at ease. Bring him at ease. Ask him, where do you stay? What job you are doing? Since when you are in this field? Ask him such question which he has to answer affirmatively. Because his lawyer has told him, whatever he is asked by the defense lawyer, say no. But if I say you are a teacher by profession, correct, you are doing some kind of service. Have you received some award or something? He may say that this defense lawyer don't know anything. But then this will break his psychology to say no. Bring a rapport, means try to develop a rapport with a witness and then go to the in detail. So these are the skills. Cross-examination, there is again no topic, no subject in the law. This is a thing which you have to develop with practice, by following senior lawyers, by reading all these, our three main acts, and try to master the things so that you able to use this with the help of BNSS and Bharatiya Saksha Adhiniyam. So with this, thankful to you, and what you say in your language, Huble Shibun. Thank you.
Thank you very much, sir, for this very meticulous session on the various provisions of which will, I believe, will be very useful for the counsels who are here. I believe all of you have noted down, and with sir's permission, if so, we may share the PPT with them.
Yeah.
Presentation. Yes. So, if you are interested in having the PPT, please contact one of the staff who will be here, we can share or you can share your email IDs, and then we can have the PPT circulated to all the people who are present here today. Thank you, sir, again, one more time, very much for this very meticulous going through of all the provisions. On behalf of the High Court of Meghalaya, the Meghalaya State Legal Service Authority, and also the State Judicial Academy, may I request Madam Elijah Marak to kindly felicitate our eminent resource person as a token of our appreciation and love. Thank you, sir. May I request the registrar, joint registrar, sir, to kindly escort the resource person off the dais. Thank you. Now we'll break for lunch as intended. We're on time. So as if I'm sure all of you had the program, we'll be breaking for about an hour, maybe 5 minutes here and there. Please try to be back on time. I know there's a lot of rush for the food, but I request everyone if you can be here latest by 2:05 or 2:10, so that we can quickly go through the last session and also have the interactive session. Now we can break. For those people who are coming for the first time, I think, or the lunch will be served on the floor below this. You can follow the crowd. I'm sure it'll lead to the food. Thank you so much. Good afternoon, everyone. I request everyone to kindly be seated. Thank you. I believe everyone has got lunch. Thank you to all the participants for being with us post-lunch. And also we thank the resource persons and all the distinguished invitees who are here with us. As we move on to the third session, working session for the day, this is as we move on to the third session of the day, I want to thank everyone once again for being with us throughout the day. Though I know it's been a long day, we request that you kindly give us a patient hearing until the end of the session. And like earlier discussed, there will be an interactive session. Please do take the time and the opportunity to speak to the senior counsels who are here. They have a wealth of experience with them. I'm sure you'll be able to take away something from this, from these training sessions, the refreshers course. I believe you've already learned quite a bit already from the first two sessions. And through the interaction, you'll be better equipped. If you have any doubts, please don't be embarrassed to ask. Please do use this opportunity. It's not every day that we have people with a wealth of experience who are in our midst. To my fellow judicial officers, I would like to, on a lighter vein, share the words of Alfred Lord Tennyson, that there's not to make reply, there's not to reason why, there's but to do and die. We don't have any options, so we're here. Also, the third working session, the topics which will be taken up are trial advocacy skills, importance of examination of the accused under Section 351 of the BNSS, or the corresponding Section of 313 of CRPC, and the role of the trial judge and judicial participation during trial proceedings. When it comes to the role of the judge, I generally like to, it's just as a joke, I like to refer to one case from the Punjab and Haryana High Court, Nirmal Singh versus Tarsim Singh, where one of the principles was that judges are not expected to know the law, but there's an absolute presumption that the judge is only an adjudicator expected to balance the two sides, but the lawyer must know the law. So the burden is on all the lawyers to know the law, to be diligent. Please do take this time to sharpen your skills. With this, I request the registrar, the Joint Registrar, come Officer on Special Duty to the Chief Justice Secretariat, Shri B.M. Sangma Sir, to kindly escort the eminent resource person, Jan Jevave Sir, and the other eminent resource persons to the dais. With these few words, I give the time to Jan Jevave Sir ji to kindly take the time, and after which we will move on to the interactive sessions after his session. Thank you.
Good afternoon. I know how it is difficult to have an academic lecture after having such a delicious food. And I guarantee that I will try to brief you in such a manner that you will not slip and we will interact. And that's why my two resource senior members are also with me, because we'll keep on interacting with each other. So I'll be putting the question not to test your knowledge, but to test that you are not sleeping after the lunch. So be active, and thank you very much. it's always a learning process. Whatever years you are putting in a profession, law is a dynamic thing. What was a meaning of a marriage 30 years in the law is not a today's meaning and interpretation. It goes on changing because the law is a need of the society. And by passage of a time, society changes. All the customs, all the conceptions and the perceptions of all fields goes on changing with the passage of a time. And therefore, law is just an application of a rule for the society, and therefore it changes with the passage of a time. So friends, definitely that I will be on a topic. The topic given is a trial advocacy skills. Then second topic is about the importance of Section 351, that is old Section 313 of the CRPC. And third one is the role of a trial judge and a judicial participation during the trial proceedings. So honorable judicial officers are also in this seminar. So I will just take a liberty with the permission of all the honorable judicial officers that considering that large number of the young lawyers are there, some basic principles will be talking and we'll try to quote some important judgments on the issues so that you can make a proper search. So definitely first part is the trial advocacy skills. What is the role of a lawyer? You are all the lawyers of the mobile generations. You will find one recent video of a senior lawyer, Mr. Kapil Sibbal, from a Supreme Court. Because after now we have completed 75 years from adopting and enacting Constitution of India. It was adopted from 26 January of 1950. Since then, 75 years are completing. So while explaining the role of the lawyer, a very fine speech has been given by Mr. Kapil Sibbal, and you should go to the Google and see his speech. And mainly he says that we all, whatever work we may be doing, we all are the protector of the Constitution, the spirit and the letter of the Constitution, and we may be doing a trial work. It may be a lawyer, it may be a defense lawyer, it may be a prosecutor, it may be a judge. The basics which will govern the trial is a constitutional mandate of finding a truth from that adjudication. Satyameva Jayate is our principle on the basis of which we all know. You have seen the logo of a Supreme Court? Anybody of you? You have seen the logo of the Supreme Court? If anybody has seen, please raise the hand. You are not sleeping, na? Yes or no? No. Sir, you have seen. But I must not ask you because you are a very senior person. On a logo of a Supreme Court, there is one slogan. You can have that logo from a Google. And on that slogan it is written, sir, Yato dharmast tato jayaha. Yato dharmast tato jayaha. What's the meaning? The meaning is that dharma should survive. And what is dharma? Dharma means truth. Truth should survive. And from where this particular slogan has been taken? This slogan has been taken from Mahabharata, and that too when Duryodhan, before the war, Mahasangram goes to his mother Gandhari for the blessing of the Gandhari. And while giving a blessing, normally what one mother will give a blessing to a son who is going to the war, what should be the normal blessing of the mother? Vijayi Bhava. He is a leader of 100 sons of Gandhari, and tomorrow he is going for a war. And Gandhari is giving a blessing, Yato dharmasta tato jayaha. He should win who is in favor of dharma. He should win who is in favor of truth. Dharma means truth. So he should be successful. Now, if a mother gives this blessing to a son, then the three officers of the court, one is a judge, one is a prosecutor, and another is a defense lawyer. All are there for the adjudication of the facts and for ultimately find out what is the truth. So everybody is supposed to follow the principle, and that's why Supreme Court in its logo takes a slogan, Satyameva Jayate, Yato Dharmasta Tato Jayaha. And therefore our role first of all as a lawyer is to protect the truth while making an adjudication of the facts for contesting a civil case or the criminal case. You may be a defense lawyer, you may be a criminal lawyer. Your job, your role, and your principle is to stick up to the truth. A defense lawyer is given a brief by the accused. A prosecutor has been given a brief by the state. Both will be putting the facts, both will be gathering the facts and making a scanning of the facts in accordance to the law and procedure. They will be putting that much facts to the court which are truthful. That is their duty. And when you are enrolled to the Bar Council, when you get a certificate of a license of a practice, I don't know whether you got it or not, you get a booklet of a professional duties and ethics. And in that, all duties, you are supposed to follow that duty. What is your duty towards court? What is your duty towards the client? What is your duty towards the society? What is your duty towards the opponent, brother? All that duties, responsibilities, and your role is attached to your license. Your license is subjected to that all rules and regulations. And if you are not following that, you are subjected to a professional misconduct and withdrawal of the license. On the basis and on the condition of that, your license is there. And therefore, you should be full of a mindset that I am here as a law officer, whatever my designation will be, it may be of a prosecutor, it may be of the defense lawyer, and after from an advocate, whenever I become a judge, all of three have a same duty, and that is finding of the truth in accordance to the procedure and in accordance to the law. And that is your duty. And that duty has given you a special status. Special status, a very special status. You are called as a person in a noble profession. I must tell you the importance of this word noble profession. Nowadays, people does not think it so seriously that I am in a noble profession. Many times, some of the young lawyers feel that I'm here to earn the money. Yes, you are there to earn the money, but you are not here basically to earn the money because you are in a noble profession. And what is this noble profession? One case I will tell you. Doctors are also professionals. They also, by their professional skills, save the life of the human beings. Advocates are professionals. By their own skill, they try to find out the justice and try to give relief to their clients. These are two duties of the two professionals. You must be knowing if a doctor wants to start his clinic, he is governed by the he is governed by the law as a commercial establishment. Whatever law of your state will be there, Shop Act license is required under that particular law. If an advocate wants to start his office, whether such Shop Act license or whether it is treated as a commercial establishment, what is your perception? Can anybody tell whether the office of the lawyer is a commercial establishment under law? Anybody knows? Yes, it is not a commercial establishment. Why? The matter went into the writ petition. And in that writ petitions, the doctor challenged that why only the doctors are treated as a commercial establishment. We are also in a noble profession. We also save the lives of the peoples. And advocates do their duty of a justice. Both are in a noble profession. Then why doctors are commercial establishment and why the advocates are not a commercial establishments? The answer was given by the judgment of a Bombay High Court. And they said that whatever, yes, both are the noble profession, no doubt. But whatever the noble profession doctors are doing, they are doing for an individual. And whatever the noble profession the advocates are doing, they may be holding a brief for an individual, but they are not working for an individual. Justice is not to be done. Justice must be seen to be done. You know this principle? Justice is not to be done. Justice must be seen to be done. So when you are holding a brief for a client, you are not only holding a brief of the client, you are holding both. It may be a prosecutor, it may be a defense lawyer. You are holding a brief for the society. You want to tell to the society that if such type of a wrong will happen, the result will be this. This will be the decree. This will be the punishment. And therefore, the Bombay High Court held in that judgment that doctor's work is for a right in persona, whereas the role of the advocate is for the right in rem. And therefore, considering this right in rem, this is not a commercial establishment. You may be doing good things. Both are charging the fees. Still, this profession is in the interest of society, whereas this profession is in the interest of an individual. And therefore, the status has been differentiated, and still, the advocates are not a commercial establishment. By the way of free advice, if anybody is charged with a commercial electricity charges for the advocate's office, you can apply that this is not a commercial establishment. Kindly don't make a charge of the commercial establishment. So this is a concept of a profession. And with this concept, when you come to a trial, particularly the today's subject, and when you want to do an advocacy of the trial, you are doing a lot of things. You are handling the human beings, you are looking the circumstances, you are meeting the society, you are looking the various documents, whether it is a civil or a criminal. So in all this process, the prime role of the lawyer for developing your advocacy, for developing your profession, for maintaining the status of the profession in the society is maintain the truth and don't do an untrue things. Don't propagate any untruth incidents. With that basic principles, whenever you will work, I know that this is not so easy in a practical life. But whatever the wrong things are coming before the courts, you should not be party to that. You should not advise anybody to sign a illegal document or create an illegal document or create a false evidence, false witness, or to make a hostile witness. All you should not be party to that. And therefore your role should be understood. So basically, when you go to these civil trials, friends, you know, when the trials are there, I'm told that initially in this state of Meghalaya, it was under the control of the executives. The trials was conducted through executives. And since last 15 years, now the court mechanism is there. And initially the CRPC, procedural law, or the CPC was not strictly applicable. Correct, sir, if I'm right? And recently the government has passed a notification, now it is applicable. Now, initially it was applicable in a spirit only and not by letters. Means not to be strictly followed, but a principle to be adopted. Whereas now it's a notification and you are supposed to strictly follow the procedure. So initially it was a criminal procedure code. Now it is BNSS. Then there was an Evidence Act, and now it is a BSA. All these provisions are practically similarly. We are coming from a old generation, putting 40 years in a practice. So naturally, we are well acquainted with the terminology of a CRPC and Evidence Act. So kindly excuse if you don't refer to that new act, you can find out the corresponding sections. So 5 types of a trial in a criminal trial you will find out, 5. Summary trial, small one. Then summons trial, another one. Then warrant trial, another one. Then wish trial. After warrant, wish trial. Sessions trial. Okay, 4. And which is 5th one? POSCO, NDPS. You have heard this? Anti-corruption. All these types of cases. 5th trial, special trials. So 5 basically trials are there. Procedures are different. In a CRPC, you will find that different procedure for summons, warrant, and everything, session trial. Separate. There are special trials are concerned. There are also special statute. You have to follow. If a case of an anti-corruption is there, you have to follow the anti-corruption law, NDPS law. Now POSCO is there. So whatever the special trials are there, along with the CRPC and the special statutes, in combination the trial will be conducted. So there are the basic 5 trials. Then comes procedure is of the CRPC, Criminal Procedure Law. It's like a railway track. When the trial will travel from filing of the FIR till completion of the charge sheet, and from charge sheet to conducting the trial, it will follow in a particular direction. It is like a railway traveling on a railway track. So this procedures law, whether CPC or CRPC, are the tracks fixed by the courts and by the provisions of the law, codes, that the trial will go in this particular fashion only. So after this particular section, this section, after this, this, and it travels in a particular manner. It cannot be vitiated. If you go there and there, it will not be allowed. You will have to go by the procedure only. Many times our law students are there, not for the lawyers, but they are influenced much by the films. And if you see the Hindi films, many times the trial is going on, the lawyer is moving from here and there. My lord, मेरे पास एक चश्मदीर गवाह है. होता है ना ऐसा? And then mostly in a horror films, in a court scenes, already the half evidence is over, and the lawyer immediately gives a call, and one chashmadir gawah, particularly lady in a sari, white sari, enters from the doors and directly comes to the witness box. Now the law students, this never happens in a court, because there is a something system like a charge sheet. In a charge sheet, there is something like a quoting of the witnesses. List of the witnesses are there. Statement of the witnesses are there. Unless previous statement is recorded by the police and you are quoted as a witness in a charge sheet, you can't enter in the trial. So ऐसा कुछ नहीं होता है. Filmy नहीं रहता है. It's nothing filmy. It's a very procedural thing. So that particular concept from law college itself, you should keep yourself. You should see the movie. I will tell you, there is one book written by one scholar, and he has given a name of 50 movies. And that movies are such a nice movie. If you see, you will find out how the analytic mind of a jurist can be developed. You can see the Hindi movie, Ek Ruka Hua Faisla. Some of you must have seen, otherwise you can see. When we will come to the role of a prosecutor, you can see the movie Chicago Trial. What is the role of the prosecutor? If it is a question of making a cross-examination in a criminal trial, you should see the film Eyewitness, English movie. Entire 2.5 hours. A witness has been examined by the lawyer and the judge. That's the only scene. But entirely 2.5 hours, entire audience is stick up to the chairs. It's such a dramatic thing. So trial is a very dramatic thing. And in this drama, all these actors are there to find out the truth. And ultimately, in this truth, what is the role of the defense and prosecutor and the judge? That today we are discussing. So you should understand that procedure is important. By procedure, you should go ahead. Then comes an important aspect of the evidence. What is evidence? Section 3 of the Evidence Act. Okay? Evidence. Anybody can give 3 words of an evidence? In the 3 words, how the evidence? Evidence means, what is evidence? Yes, anybody can tell me that what is evidence? Nobody? 3 things. Statement means witness. Document. And third one, recently added, your generation should know that. What is that third one? Yes? Electronic record. 3 things. Evidence means examination of a witness and their statement before court, in bracket, on oath. Evidence means a document produced before the court for its examination, and electronic record. These are the 3 criteria of the evidence. You should understand that. So, statement, document. How to record the statement is again given in section 60. Direct evidence, oral evidence, we call as a evidence of the witness. Okay, that is a direct evidence. So direct evidence, the person is coming in a witness box and you are examining that. He will be examined 2 ways. First of all, the person who calls him as his witness will record his statement, and it is called as a chief examination. Correct? And the opponent will make a cross-examination. Unless and until chief examination and cross-examinations are done, it is not an evidence. If only chief examination is done and cross is not taken, it is not an evidence. So evidence is this chief and cross-examination. That witness, what he is supposed to tell the court, section 60, you must read. The oral evidence. His evidence is an oral evidence. And what he is supposed to tell to the court is relating to his human capacity, to body. What I have seen from my eyes. What I have heard from my ears. What I have spoken. What I have felt from my various sensations. Various sensations of the body is there. Emotions are there. That personal perception of that particular incident, he can tell to the court. and that is his oral evidence. Then is subjected to the cross-examination, and the material cross-examination will be done what he has stated in his statement before the police as far as criminal case is there. If any document relating to him is there, if a letter is written, if some document is done, some agreement is done, and it is relevant to the subject matter, then you can make a cross-examination on his statement, on his letter, on his agreement, and try to find out a truth of the version of that particular witness by making a proper cross-examinations. So that particular thing is possible to the advocate when he collect the correct facts. When he sees the spot of an incident, and by taking a correct information, by reading all previous documents, you can find out which are the infirmities, which are the inconsistent things, and that particular material you have to pick and put to the witness. That what my learned friend has explained to you, cross-examination. The skill of the cross-examination basically can be developed by taking a correct instructions, by making your own mind with a habit of developing a clear questions. Your questions must be very clear, not an ambiguous one, and the answer should be favorable to you. So in the morning, yesterday inauguration also, Honorable Chief Justice said that in a cross-examination, particularly in a criminal trial, the skill is not of asking. The skill is of not asking wrong questions. What is to be said is important, but more important is what not to be said. If you are putting a wrong questions, and by that questions you are asking such a particular facts which will bring your own accused towards the conviction, then you are responsible, friends. You are responsible to the extent of your professional license. Keep in your mind. We are dealt with hundreds of cases because of two questions of a lawyer. When an accused is convicted, his professional capacity is subjected to the challenge. And it was challenged and it was rejected and the license was cancelled. So this is the role. Easily, if you ask any question without making a preparation, because every word you are asking that is going to be recorded as an evidence. So before that, you will require a very great hard work, homework. If that homework is done in a courtroom only, then definitely you are going to fail. So you have to work yourself prior to the trial very hard and then do your work. So on this procedure and evidence, you must be a master. With the facts of the case, you should be a master. You should develop a skill of recording a fact in a particular manner. You can go to the Google. You will find one lecture of a very designated big senior lawyer from Bombay High Court, Janak Dwarkadas, in a lecture series of a Bombay Bar Association, how to take the instructions from the client. And that is the greatest skill the junior lawyers, every lawyer, I will not say only junior lawyer, every lawyer should derive, because when the client comes to you, he will only put that particular facts to you which are favorable to him. And he will always try to suppress the facts which are not favorable to him. It's your duty to assume and presume that unfavorable facts and take the instructions of that particular unfavorable facts from the client so that your factual knowledge should be complete. You should prepare a chart, whether you are dealing with a civil matter or a criminal matter. The date, the incident, the material, which witness, which document. That chart should be prepared by everybody when the client comes to you by taking a proper instruction. You should study that particular factual analysis, make the factual analysis. See the sequence of the incidents, date-wise. What happened in this date? What happened on the next date? What happened on the next date? what relevant witness is with you, what relevant document is with you, and what is that material. This particular factual aspect must be prepared by you. And then, once you are master of the facts, you should turn towards the other part of the law, that is a procedure, that is evidence, or a substantive law in the matter. So first duty is to develop this skill, how to take the instructions on the client. About in a evidence, in a very correct word, my learned brother has explained you, 3 things should be on the mind. A particular fact. It may be of an oral evidence, it may be of any documentary evidence, or it may be of an electronic record. 3 things are there in an evidence. You have to prove either the witness statement, you have to prove either the document, or you have to prove the electronic record. That is evidence. For that, 3 criteria. Proved, disproved, not proved. He has explained it, I will not take the time. And the key word should be remembered by you. Proved, the fact, existence of the fact. Proved means existence of the fact is so probable that a prudent man of a common sense will believe that this fact exists. That is proved. It is not a complicated thing. It is based on the prudent principles of a common man. A particular fact should be put in such a manner that court and everybody should feel that, yes, it exists, or its existence is probable. And any common man will believe that this particular fact exists, or its existence is probable. That is proved. He has explained you. A mirror image of the proved, exactly opposed. Just replace the exist with non-existence or inexist. A fact inexist or the inexistence is so probable that the prudent man will believe that such a fact does not exist. That is disproved. And when it is neither proved or not disproved, it is not proved. So you have to bring your evidence in 3 compartments. Ultimately, your mind should be fixed. I want to make this particular oral evidence into compartment of the proved. Or if you want to oppose it, your concept should be clear that this particular evidence should be brought in such a manner to the court by making such a cross-examination that court will believe that it does not exist. So I will disbelieve this particular witness. I will disprove this particular fact. Your lawyer, your concept should be clear. The fact, fact in issue, relevant fact, then proved, disproved, or not proved. So the sequence starts from the evidence. What is evidence? What is statement? What is document? Document is also defined. What is document? So document is a very wide language, and you should understand all that thing. Today we don't have that much time. But start with evidence, 3 things, then come to the fact, then come to the fact in issue, then come to the relevant fact, then come to these 3 compartments: proved, disproved, not proved. So this is the first aspect you should keep in your mind, that with the procedure, CRPC, I have to cautious about the evidence. That's my duty. And for that duty, I have to keep this sequence in my mind. Evidence, fact, fact in issue, relevant fact, proved, disproved, not proved. 6, 7 words are there that should be always written in your diary. And you should always try to go on thinking of that particular word to develop your skill of the advocacy. If you are doing that, you are really a skillful lawyer. So friends, with this introductory part, when it comes to a criminal trial, the FIR, sir has told us, the FIR, by an FIR is not a Bhagavad Gita of the criminal trial. It is just a starting point of the criminal trial. A criminal action is put into the motion. That is only the meaning of the FIR. And with that FIR, the investigation starts, the investigation is completed, and a charge sheet is filed. The first part of an investigation is over, charge sheet is filed. Once the charge sheet is filed, the second part of the trial starts. Now, whatever the charge sheet is there, prosecution want to prove that charge sheet, and defense lawyer want to disprove that law. So proved and disproved. Proved is the responsibility and a burden on the prosecution. Disproved is the burden of the defense lawyer. And once this particular compartment is in your mind, you become a technically correct lawyer who understand the procedure, who understand the evidence, and now you are going to face the trial. Now, when you are going to conduct the trial, as an advocate, these all are clerical jobs, CRPC, evidence, these are all clerical jobs. They are written in the books. What is your main job? Your main job is to understand the jurisprudence. The next important stage for a trial advocacy is the jurisprudence, understanding the jurisprudence. What is jurisprudence? You must have read the jurisprudence, na? What you can say about the jurisprudence? Anybody? It is called as a Nyaya Shastra. It is called as a Nyaya Shastra. It's a science of justice. Like a chemistry. A chemical is mixed into B chemical. It creates a C chemical. It's a science. A physics, third rule of a Newton, action is always replied by the reaction. Like that, jurisprudence is there. Jurisprudence is also a science of a justice. It is most important. As far as trial is concerned, Honorable Chief Justice, our all two speakers have already spoken on the jurisprudence of the criminal trial. What is the basis of the criminal trial, jurisprudence of the criminal trial as per the Constitution? Because when we are conducting a trial, we have to conduct that trial as per the constitutional mandate. Whatever the constitutional mandate is there, according to the constitutional mandate, we have to conduct the trial. And as per this constitutional mandate, when a particular person is involved in a criminal case, he has been prosecuted, charge sheet has been filed, matter is going for an evidence now. So what is the principle on the basis of which this trial will be conducted? Whether any burden is there on an accused or the burden is on a prosecution. And for that, which science is to be applied? Do you know that science? Which one? Yes, please speak out. Anybody? Yes? I'm not getting. Article 21-22. But the principle is a principle of innocence. Chief Justice in a yesterday's speech told you that 100 guilty person may be free, one innocent person should not be punished. That is a principle of innocence. There are two principles of jurisprudence on the basis of which the trials are conducted. The criminal trials are conducted on the jurisprudence of principle of innocence. It will be presumed by the law that the accused person is innocent person. The prosecution has full burden and responsibility to bring such evidence whereby it will be held that he is the only person who has committed a guilt and there is no doubt in that particular circumstances. That is a principle of innocence. It's a very strict principle. Suppose one glass is there, complete glass is there, the window glass is there. and one stone is thrown to that glass, the glass will be broken. All pieces of that glass to be brought together, and that should be arranged in such a manner that by pieces of the gap, there should be again a complete glass. There should not be any hole. There should not be any gap. If such type of a hole is there, such type of a gap is there, it is called as a benefit of the doubt. It's not an absolute proof. So it can be said to be evidence brought by the prosecution in a criminal trial to hold the accused responsible for punishment, to say that his guilt is proved only when this principle of innocence is observed, and that type of a concrete evidence with having no doubt, no benefit of doubt can be given to an accused. In that circumstances only he can be convicted. That is our basic principle of a jurisprudence. If it is a civil trial, this strict proof is not required. It's a preponderance of the probability. Probabilities to be weighed by the judge, and whichever is the heavy probability, in their favor decision will be given. Absolute 100% proof may not be there, but out of two parties, one party is heavy and one party is not that much heavy, then this party having a preponderance of probability. Preponderance means a heavy weight of the probability or heavy effect of the probability will be given benefit of the court litigation and the decision in a civil trial. In a criminal trial, accused will have to be convicted only when this principle of evidence is proved, and on the basis of that, particularly this type of evidence is there. So friends, jurisprudence is absolutely an important skill of an advocate. Whatever matter you are dealing with, every matter has a jurisprudence. You may be dealing with a tenancy matter. It has its own jurisprudence. You may be dealing with a transfer of property. It has its own jurisprudence. You may be conducting a murder trial. It has its own jurisprudence. You may be conducting any other matter. Every matter in a court, it is a basic duty of an advocate to understand the jurisprudence applicable to that particular subject matter and to conduct the case in accordance to that jurisprudence. All this CRPC evidence is important, but they are the ultimately clerical jobs. The skill of advocacy as a constitutional expert, as an expert of the law, is to argue the jurisprudence. And you should develop your jurisprudence mind, and you should go on reading that, the judgments and the literature. Solomon is the best author, whose book on the jurisprudence, right from the student edition to the big commentary, must be in a library of every lawyer. One good dictionary, particularly explaining the interpretation of a particular words, must be in your library. And every time, whenever the difficulty comes, you should go to that book, find out the meaning, and accordingly go on, read the sections or make your own interpretations. And that's very important, friends. Two words I am lastly telling you how it is important to understand the jurisprudence. You must have heard two words in a criminal trial: intention and motive. You have heard that? Yes. Today we don't have a time, otherwise we would have an exercise to understand what are your understanding, what is the meaning of an intention and what is the meaning of a motive. Whether there is any difference in an intention and a motive, any difference is there? Yes, anybody who wants to say that difference is there, please raise your hands. The difference is there. Difference is not there, yes, you are not raising the hands. There is no difference between the words intention and motive. There is a difference, friends. And jurisprudence teaches you what is that difference. The example can be quoted that suppose a dispute of the land is there. One particular person wants that the adjoining land must be given to him by the another owner, and it should not be transferred to any other person. And for that, he tried to create a force. The owner comes on a site, and this person, with a motive that this land must come to him, had a fight with that owner. And out of that, some injury is caused or a murder is caused. He beats that person immediately after the talk between the particular persons. The motive is that the land should come to him. And the intention was to beat that man, to threaten him that you should not give this land to any other person. So intention, jurisprudence says that it is an immediate state of mind. Intention is an immediate state of mind, whereas motive is an ultimate state of mind. In a criminal trial, you must prove intention to hold a particular person guilty. You can prove a motive, but you may not prove a motive. Still, if an intention is proved, you will held guilty. So intention is most important in a criminal trial. What is the intention and how the intention was there or intention was not there is an entire crux of the matter in a criminal trial. As a defense lawyer, if you work on a particular offense, you will have to show that there was no intention of an accused to do this wrong. When you will successful to prove this particular thing, that there was no intention of an accused, you will be acquitted. And if an intention is proved, motive may be proved or may not be proved. Still, if an intention is proved, you will be held guilty and you will be liable for the conviction or a punishment. This is an important aspect of the jurisprudence which in a criminal trial you must understand, friends. Now there are, as told, there are three players in this trial. One is a prosecutor, another is a defense witness, and another is the judge. So what are their roles? What is the role of a prosecutor? He represents the state. State says that an offense is committed under a particular section and this accused must be punished. For that purpose, certain witnesses are collected by the state and certain documents are collected by the state, or some other evidence in a technical form is collected by the state, and including all that material, a charge sheet has been submitted to the court. So charge sheet is a collection of all this evidence. It includes statement, it includes documents, it includes electronic record. All this evidence is put in a charge sheet and it is submitted to the court that this is our case, this is a prosecution case. On the basis of this, we want to lead an evidence and we want to convict this accused. Now the role of the prosecutor starts after the charge sheet is filed. Till charge sheet is filed, there is no role to the prosecutor. And till that time, the police machinery is working. They are the one party. Police or the state government is one party to the case. They are representing a people at large. There should be peace. There should not be any illegal activities. And law and order should be there. It's a responsibility of the state as per the constitution. And therefore, police machinery is meant for making all this mechanism. So police represents the people at large. But they are ultimately a party to the proceeding. Then what is the role of the prosecutor? Whether the prosecutor is a mouthpiece of that police or he is something else, that should be understood. Because initially, till 1976, if I am wrong, Chavan sir, you can correct, the word used was police prosecutor. And in 1976, there is an amendment, correct? I'm not right, wrong? It is made as a public prosecutor. So the role of the prosecutor is of a public prosecutor. He again represents independently the people at large. He is not only a holding of the brief of the police or the state, but he is representing the cause of justice for the people at large. Here comes the important role of the prosecutor, and that's why I told that you see the movie on YouTube, Chicago Trial. What is the role of the prosecutor? How prosecutor should behave? For what he should stand? How strictly he should do his duty? At the same time, how he should be concerned for the justice. What is the true justice? His duty is not to convict the accused. His duty is to correct, is to place the correct facts, the correct witnesses to the court in support of the charge sheet, and to put a truthful situation before the court to show that, to find out whether the accused is guilty or is not guilty. That is the role of the prosecutor. And therefore, he is not a mouthpiece. He must be fair. He can't ask the leading questions. When he makes an examination of the witness, you know what is the leading questions? In an Evidence Act, 137 section defines the chief examination, cross-examination, leading questions. The leading questions are that questions in which, in question itself, the answer is there. That is called as a leading questions. In a chief examination, nobody is entitled to ask the leading question without the permission of the court. If you want to make a leading question in a chief examination, you will have to take the permission of the court. And if a court permit, you can ask the leading question. So prosecutor is making a chief examination of the witnesses, because witnesses are for the prosecutors, for the state government. So he is making a chief examination of the witnesses without asking a leading question to the witnesses. If that witness is not supporting to the prosecution case, he has given a statement to the police, but in a witness box, he is not stating in accordance to the statement given to the police. Then what is to be done? This type of a witness is said to be a hostile witness. And this hostile witness will be cross-examined by the prosecutor. So again, his role now changes from a chief examination. He himself makes a cross-examination of that witness. In a cross-examination, now he can ask the leading questions. So if his witness is not supporting the prosecution case, that witness is not to be thrown away. The same prosecutor will ask him the cross-examination. And in cross-examination, he will try to find out some material which is helpful to the prosecution case. So once that role is over, then the defense lawyer will make a cross-examination. So role of the prosecutor is try to bring all this material before the court. Suppose in hands of prosecution, some material is there which shows that accused is not guilty. Now he is on a prosecution side. His duty is practically to support a charge sheet. Charge sheet is meant for holding accused guilty and to send him to behind the bars, give him punishment. That is the role of the state government, charge sheet, and the prosecutor. But in the hands of prosecutors, suppose some material is there which shows that accused is not guilty, then what is his duty? Whether he should suppress that or whether he should give to the court. He should not suppress that material. If that material is there, it may be in a charge sheet also. It may be subsequently filed by the government also. Or it may be brought by the accused on record also. The prosecutor should not suppress that. If he suppresses that, he is also a lawyer. He is also subjected to the professional ethics and conduct rules. And under that rule, if a prosecutor suppresses a material which is supporting the accused innocence, then he is doing a misconduct of his profession. And he will be held responsible for the action of the misconduct. So his role is to have a fair trial. And with that role, he will come to the trial. Now, what is the defense? And what is the duty of the defense lawyers? Most of you are defense counsels. So naturally, the defense lawyer is having a job of getting an acquittal. There is no other responsibility. He must work in such a manner that he should try to protect the interest of the accused. He should try to safeguard the accused from bringing any incriminating material on record, and by making all the proper investigations, instructions in detail. So the duty of the defense is to keep in mind the principle of innocence, keep in mind that any material which is incriminating to the accused and his defense should not be brought without any proper procedure before the court. His duty is to take the correct instructions. His duty is to make an independent investigation. Investigation of the charge sheet is already done. But who is that particular witness quoted? What is his background? Why is speaking against the accused? What are the real reasons? Whether there is any enmity, on the basis of which this enmity was created. All these particular things should be brought. If there are punch witness, whether they are a habitual one, whether they are repeatedly signing the panchanama of the police, and whether such type of a witness has not done an actual panchanama, these all factual aspects they should bring. They should make this, the investigation of these particular aspects, and must be prepared to put a correct, truthful facts before the court. The defense lawyer must visit the spot of the incident. Most important thing. On spot, he should verify the panchanama, spot panchanama. What is written in a spot panchanama and what is the actual circumstances on the spot. He should verify, read the panchanama and go to the spot. See whether there is any tree, whether there is a stone, whether any road or whether any mountain as written in that particular panchanama, whether it is there or some different situation is there. Because most of the time, police do not take a trouble, they just write the panchanama in a police station. And naturally, many times, therefore, the contradictions are created. So you should go on a spot as a defense lawyer and verify the spot panchanama. That is most important, friend. And in all this investigation and instruction, you should find out what are the inconsistencies in the charge sheet and the actual circumstances, which can be a supporting thing from the charge sheet for the defense. Now, sir has given an elaborate lecture that how the defense is to be created. When in our junior times, sir will agree, the seniors used to take 5 copies of the charge sheet. And still, when we go for a trainings, lot of young lawyer comes to a training in our academy. You can visit our academy in New Mumbai. It's the first advocate training academy established in a country, a big institute. And there we do all this exercise. 5 charge sheets are given to 5 persons. One senior sits here and start reading. One person will read charge sheet, another will read charge sheet, another will read charge sheet. Whenever 2, 3, 4 persons will read the charge sheet, you will find out the prosecution case and some outlets to that prosecution case. These are your defenses. You should not take some abstract defenses. You should go with a prosecution case because the mindset of the courts are there when FIR is launched. Something has happened, something wrong has happened. Otherwise, why the FIR will come? बोलते ना आग होता है तो धुआं निकलता है. Those are the mindsets of the judges also. If you said that no, everything is wrong, everything is false, then why FIR? Why charge sheet? Why such a witnesses? Why these all documents? So you should go with the charge sheet story and create your defenses. You have to just create another outlets of the charge sheet. No, this is a different way. This is a different way. These are your defenses. These defenses are possible when you read a charge sheet collectively. 2-3 persons should sit together because everybody's eyes and everybody's mind are different. And if not at all, at least you yourself as an individual, read the charge sheet for minimum 3 times. and you will find that some sort of a defense is already hidden in that charge sheet. If you are successful, find out that particular hidden defense, then you are successful. Then court will believe, yes, this is up to this, it is correct. But then it seems to be a diversion. Why the police has taken the charge sheet in this direction? There is a diversion. And that is possible, which is a benefit of doubt, or which is beyond a reasonable doubt. And therefore, that is your defense. This type of a defense creation is a basic duty of a defense lawyer. And once you have understood the charge sheet and the facts, then your jurisprudence, then your law, and then your case law should start operating. You should always read the sections which are made applicable to that particular offense again and again. Sir might have conducted 5,000 murder trials. Still, when charge sheet comes, charge sheet is written, he will again go to the section of 302 or 103 now, and he will read that section. When you read with that background of the facts of that particular charge sheet, the full stop and comma written in that section gives you different meaning, suitable to that particular facts. And therefore, it's your duty to read the section first, which section is applicable. Find out what part of the section is not applicable to that particular facts or that particular charge sheet. And then jump to a case laws. Nowadays, we are living in a chat GPT, and just we put that so-and-so, 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 so-and-so has happened. Tack, which case law? So case law, the facts are different and law is different, and you are putting that case law before the court. And then some court will make a observation that you are not read the case law and still quoted the case law. It happens, particularly in a time of an artificial intelligence. You will find a judgment coming from the apex court that blindly, if you are going behind this artificial intelligence and mobiles and chat GPT, you will find that many fabricated case laws are inserted in that softwares. And if you are using that fabricated case laws, false case laws, and making your pleadings, making your arguments, you are liable for the professional misconduct. It is a recent judgment of the current Chief Justice of India. You can read that and must be alert. And the use of the artificial intelligence is unavoidable. In fact, the old and new lawyers should be expert. It's a speed which artificial intelligence has given in this current era. We must use it. We should not misuse it. That is the question. And what is the difference between the use and misuse is a question of individual perception. That particular thing is very important, friends. So this is something, the responsibility of the prosecutor and the defense lawyer, which you should understand. What is the role of the judge? Honorable judicial officers are there. Some are sitting here. You know what is there. Their training is also going on, because they also required to be updated. And here also there is a judicial academy. In every state there is a judicial academy. The senior judges comes and they talk to the lawyers. The role of the judge, in a simple way, is a director of that entire drama. Entire power is in his hand. Entire remote is in the hands of the judge. So first of all, you should be clever and smart, that you should try to take the judge with you rather than the opposing the judge. Yes, if the judge is not listening to you, you can raise your all points and you can go in a cross lines. That's a different thing. But as said, in a charge sheet, try to travel from the charge sheet and find out some outlets. Similarly, whatever judge says, try to go with the judge and make you convince him on some legal points or factual aspect, because he is the sole authority of that entire trial. What witnesses are to be examined? How the trial is to be conducted? Which charge is to be framed? In which sequence the witnesses are to be examined? All these things are in his hand. And he has that entire power. And that all powers will come to that 313 section. Apart from 316, there is a 165 section in an Evidence Act, And in that section, any question can be asked. It's an unlimited power to the judge to ask any question to any witness. Or he can make any inquiry from the lawyer. He can put any query to the lawyer. You should not be of a mind that why judge has asked me, whether he is against me. He has all power. He is supposed to make the adjudications of the facts. And ultimately, he has to decide what is truth. So he will do all this exercise. He will put his questions. He will observe the pleader of the prosecution. He will observe the pleader of the defense. He will put the questions to parties. He will take the information. He will see the procedure. He will see the evidence. He will see what you argue on the jurisprudence. Rightly said, ultimately, you, the lawyer, has to give a material. All judges are developed by the bar. Even a Supreme Court Chief Justice has said that we are the products of the bar. They are not some foreigners. They are from our bar only. They are bar members. So ultimately, they goes and sit there as a judge. And you have to put on both sides a correct information, correct law. You have to make a search and you have to put to the judge. So role of the judge. A famous case, All India Judges Association, reported in 1992, Supreme Court Cases, Volume 1, page 119. You can take this citation. What is the role of the judge? A famous case, All India Judges Association, 1992, Supreme Court Cases, Volume 1, page number 119, by Justice Ranganath Mishra. It's a famous case. And there you will find that all roles are given. Speedy justice is not only the responsibility of the parties to the litigation or the judge. Speedy justice is treated as a fundamental right guaranteed under Article 21 of the Constitution. And if a maximum blames are coming to the system, judicial system, your state is small, but in a big state, that is pendency and delay for conducting the trials and conducting the appeals and the delay for their executions. So as far as the trials are concerned, if it is session trial, procedures should also expect that it should be speedy. You can see section 309, where it is expected that continuously the trial should be conducted. With a speedy matter, it should be conducted. So it's a public trust posed upon the judge to make the compliance of the constitutional mandate. The main duty and role of the judge is to hold a public trust for doing a justice by making an adjudication of the fact, finding out the truth, punishing the wrong person, acquitting the correct person. And that is his duty because it is a constitutional mandate guaranteed to the citizens that through judicial system, we the lawyers and we the judges will do this. This is a constitutional mandate, friends. And because of that, these particular things happen. And therefore, friends, the judge role is very important. He will record the evidence. He will follow the procedure. He will keep the atmosphere of the entire trial healthy. There should not be any threat. There should not be any pressure. There should be a free atmosphere. The judge should create that atmosphere. And it's a duty of the lawyer to remind him that your duty is to keep this atmosphere if he's not able to do that. So this particular thing, particularly in a trial, will be done only if the judge knows what is the relevant fact, if he's having a master eye on the facts of the matters, whatever is the ambiguity, whatever is the vagueness, that is to be removed by the judge. If any objections are raised for the evidence, he should record it. Let the evidence go ahead. He should not obstruct the evidence. And after completing the evidence at the time of judgment, he should decide that objection. The judge should not immediately take the objection, pass an order, because it will obstruct the evidence. So this is the role of the judge, and ultimately he can put any question to the witness, to the accused, and take the details of that Only the question is that accordingly it should be recorded that this is a question asked by the court. To court, this should be recorded. To court, these words. Your duty is that that particular recording is done in that particular manner, should be seen by the lawyer. If you are not seen, and if it is not written to court, maybe it is considered as the evidence of that witness and it will go to the other side. So that is his role. He is a quite proactive player of this entire trial, and therefore this particular role he must pay, friends. We are a short time, we will come to a last part of 313. 313 is titled as Power to Examine the Accused. Power of judge to examine the accused. Now this examination is not a chief examination or a cross examination, because this is not on an oath. When the question will be asked by the judge, it is not on oath. Bhagwan kasam sahi bolunga, that is not an oath given to that accused. Just a questions are asked. So what is the basis for asking this question? The basis for asking this question is that when the evidence is given, the circumstances appear in evidence against the accused must be put to the accused. An explanation must be asked from the accused. These circumstances are against you. This witness speaks against you. What is your say? This document speaks against you. What is your say? This particular circumstance speaks against you. What is your say? So the circumstances which are incriminating against the accused should be put to that particular accused by way of a questions, and explanation should be asked. That is a gist of that particular section 13. It can be done in two. If you go to section 313, one section A and B, in the first part, he can ask this question at any stage of the trial. May, the word used that, he may ask the question at any stage of the trial. And second part is that he shall ask the questions after the witnesses for the prosecution have been examined and before he is called for his defense. The question in generally should be asked by the court, by the judge to the accused. This is 313, subclause 1B is a mandatory compliance. The word used is shall. He shall ask. What question he should ask? What is an incriminating material brought on record by some witness or by some document or by some circumstances? Only that much. All evidence is not to be put to the accused. All evidence explanation is not needed from an accused. This much. Why this particular provision is there? Whether it is in favor of accused or it is against the accused. It is in favor of the accused. The accused is keeping mum in an entire trial. FIR started, he is not asked. Investigation done, he is not asked. Charge sheet is filed, he is not asked. After charge sheet, plea guilty is one stage, where is asked whether you plead guilty, that much is asked. He says no. Then next stage, charge is framed, only charge is read to him. He is not asked, what is your say? There is no provision. Just he is keeping mum. His role is to just keep silent. And the prosecution role is to bring the evidence. Now, natural principle of justice says that if some allegations are made against one person, without asking his explanation, he cannot be punished. That is a basic principle of a natural principle justice. On the basis of this rule is designed. Now the prosecution has completed his evidence. If defense want to give some defense evidence, he can give. Before that, the court will use the power under section 330, subclause 1B, and will ask the accused, come here in a witness box. No oath is to be given. He is to be explained. No compulsion. I am asking you, you can give an answer. No, if he refused to do that, no punishment. Yes, of course, an adverse inference can be done. But the incriminating circumstances in form of question will be put to him and answer will be recorded. This is before the defense of the accused is to be started and after the prosecution defense is completed. In between, this particular exercise will be done by the judge, and with that exercise, accused can give an explanation. Whatever explanation accused will give, he may say yes. He may say that yes, I have done this job, this particular guilt. But for that purpose, if there is a prosecution evidence, then only that can be used. That statement of the accused stating that yes, I have done a guilt can be used to punish him. If he says that in that 313 examination, that yes, I have done this guilt or I am guilty, the duty of a judge is not to take that answer directly. The judge has to warn him that, see, if you are answering this, by this answer, you may be punished. You may be held guilty. What you want to say? Then whatever answer will be there, by taking that particular answer, the judge will go forward. And whatever may be the answer, unless and until there is a corroboration to the prosecution evidence, to that effect, that particular sole piece of that particular answer of the accused cannot be the basis for the conviction. It is not a substantive evidence. What do you mean by substantive evidence? Section 60 of the Evidence Act. Chief examination and cross-examination of the witness is a substantive evidence. It is on oath, and that's why it is substantive evidence. The statement of the accused under Section 313 is not on oath. It's a formality as per the principle of a natural justice of the judge to put incriminating circumstances to an accused, and therefore it is not a substantive evidence. It cannot be a sole basis of conviction. With this concept, friends, we have to look towards this 313. Now it is 351, and that's why the role of the judge is to make these types of questions and take the answers to this particular case. There are many important cases on this particular aspect. We can give the compilation of these all cases to you, right from Supreme Court. There are many cases. Whether accused should be personally present for answering this, or whether his lawyer can answer this. The basic reply to this will be that the word used in 313, subclause 1b, is shall. And therefore, it's a mandate that he must remain present. But there is an exception. If the circumstances are such that he has been given a permanent exemption to attend the trial, if suppose he is in such a circumstances that he can't attend due to some hardship, grave hardship, or is unable to attend due to physical inability, then he can make an application. On his application, court can make two types of order. The questions will be given and a written answer to that effect of the accused will be given to the court, or even an advocate can be permitted to give an answer on behalf of the accused. So this is what a brief concept of 313 can be placed before you. Friends, it's 3:30. Some time for your questions. If questions are there, the resource persons feel it good, because then it feels that something has been penetrated. 2 meanings can be called. 2 minutes can be gathered from silence of the all audience, that they understand so well that nothing remains to be answered now, questions, or nothing has been understood. These are only the 2 meanings. We hope that when we are coming to the Meghalaya, right from Mumbai, our efforts is to put our whatever the little knowledge is there, little perception is there before you, to just give you a material of thinking I hope that by this all deliberations, you will be able to think of, try to make your own profession more skillful. Our best wishes. So we welcome you. We have a half hour given by the organizers for asking the questions. You ask questions. Whoever is an able person will answer from our side. Thank you very much.
Sir, I'll ask just 3-4 questions so that it will benefit my other junior colleague friends, Your Honor. Well, that is because they always come to me and ask about this thing, these particular questions. So if it comes through you all, learned people, more experience, then it'll be better for them. So one of the questions which they ask is that, sir, in a cross-examination, should we ask what is stated only in examination in chief, or can we ask other related questions, or we can establish our defense by asking questions which are not asked in examination in chief also?
Wait, we'll reply. Rajendra.
Cross-examination need not to be restricted to the examination in chief. Since we are challenging the credibility of a witness, defense lawyer is allowed to go beyond the scope of chief, but it is subject to showing that it is done with an intention to challenge the credibility. Now this privilege is not allowed to the public prosecutor. He will have restrict to his chief only to the extent of statement recorded under section 180 of BNSS. Clear?
Yes, sir. Some more, sir. Okay, sir. Now, sir, in a POCSO case, if the DNA report has not come and the victim has already been examined and other people are also examined, now once the DNA report comes, then I think we have a right to call back the victim to cross-examine her further.
Could you
If
come again?
I said in a POCSO case, if DNA report has not come and the trial has started, because the IO said that I'll file a supplementary charge sheet, so the court starts the trial. Then the DNA comes later, or sometimes it may not come also.
Yeah.
And the case is finally finalized.
Listen,
Then, sir, what? Can we call the victim again?
wait. As I told during my lecture, that DNA report, whichever laboratory it is, Supreme Court in Mukesh versus NCT Delhi, Nirbhaya's case, has said it is 100% correct report. Supposing DNA report has come and it doesn't say that victim and the accused are the biological parents, father and mother, of the fetus, of the child born, then there ends the matter. There is an introduction of some other person who is not before the court. So, when the DNA report is negative, you are safe, you are landing safe. But when it is positive, when DNA report says that accused and the victim child, they are biological parents, father and mother of the fetus or the child, then question arises. Here I don't see any reason to call the victim for her re-examination.
Okay, sir. In
Whatever she was supposed to tell to the court as her own case, she has already deposed. She has been cross-examined. Question is, there is a SOP. There are guidelines given by each state government to the medical officers as to how to collect the samples for DNA analysis.
Okay, sir.
Very serious guidelines are there. For example, I'll tell you.
Sir, got it.
Are you in a hurry to go ahead?
No, sir.
Let me explain. How to collect, how the doctor would collect a DNA sample of the victim child, of the fetus, of the accused. His identity, her identity must be well established. Second, the samples must be collected in the presence of two genuine witnesses. They will step in the witness box and they will depose accordingly that we were there while his sample was collected. We have signed the form, sample collection form. So two independent witnesses, then identity by way of any photo identity. For example, Aadhaar card. Then the DNA sample, that file, that tube in which blood sample for DNA analysis is collected is supposed to be packed with the plastic strip. It should be put in the box at a particular temperature, chilledness as prescribed by the government. That box will be sealed properly because the laboratory will identify the seal. Laboratory will certify that they were properly sealed as per the report, as per the DNA sample collection form that they will have to certify. Then that certification has to come before the court by way of evidence. Then whom it was handed over to? Law says the doctor is not supposed to hand it over to the policeman. Law says, SOP says, doctor has to forward it to the chemical analysis laboratory, FSL, forensic science laboratory. It should be carried by a carrier who will come before the court and will say, yes, I carried it on a particular date at so and so time. It was given to me. I signed it in acknowledgement. Then I carried it. I handed over it to the laboratory clerk. He has acknowledged it. He has put the date. He has put the time. And the temperature that is required to be maintained throughout the transit from one place to the laboratory, from that hospital to the laboratory, is to be recorded. Every documentation is a must. Then the duration in which this sample was physically examined by the chemical analyst so as to come to the conclusion whether they two are biological parents. If he has written for pretty long time, if the sample was collected by the police and it was kept in the cupboard of the police station for 20 days, 4 days, 5 days, it was wrongly handled, whereby it may get contaminated. The report is not acceptable. There are judgments. So I said, 20 judgments are there. You read the judgment so that you will understand the law. Second aspect. This all procedure, it is called chain of custody. That is to be established precisely. If they fail, DNA report doesn't become an evidence. So SOP has to be strictly followed, and then if the SOP is strictly followed, with all documents, with all persons concerned, sometime what happens, the file, glass tube, long tube, in which the blood sample is collected for DNA, it is handed over to the, by packing it, not allowed. While collecting DNA sample, if the ward boy or a nurse is there applying some medicine while taking the, if she sneezes, if she talks and her some watery portion come, contamination is possible. So all care being taken and it is brought on record by way of evidence, that DNA report would become reliable. Otherwise, not.
So can I ask next one?
Beg your pardon?
One more.
Before
just two more
that,
questions.
can you
sir.
take to section 143? Just a
can-
minute. I'll support my answer with the provision.
Maybe the next question is connected.
Just a minute, yeah. Can you see 143? 143 subclause 2. The examination in chief and cross-examination must relate to relevant fact. But the cross-examination need not be confined to the facts to which witness testified on his examination in chief.
Exactly.
That is an answer.
Exactly.
Okay?
Exactly.
Third question, please.
Thank you, sir. So one more. Please don't mind, but just few.
You
Sir,
are a spokesman for all?
my juniors, they come to me, so I'd say, okay.
Okay, you are welcome.
I'll
But
ask them
we will
soon.
like if some junior
Yeah,
ask
they'll
questions.
come. Just two more questions, sir. So you said that we can call witness under section 311 CRPC, right? The statement of that witness is not there. So is it not the duty of the prosecution to say that this witness is coming for proving this particular place? Otherwise, if they don't state that, then they will fill up all the lacunas of the case. So should it be just allowed blindly that you can call any witness by the prosecution? Or should they say that this particular witness will come and a gist of
Recall of witness.
that particular witness should be given to the defense?
See, he is entitled to call witnesses which are forming part of charge sheet only.
No, this is under section 311, I said, sir. Called under section 311 CRPC. They are
Okay,
not in the charge.
311.
So there is no, their statement is not there, sir. So the problem is that what happens is that prosecution sometimes just calls a witness. And when we ask what is the purpose, they said, oh, we'll tell in the court. No, but at least we
Listen,
should
listen.
know
I'll reply.
what is the submission they will give so that
Madam,
we know.
I got your
Okay,
question.
okay, sir.
Witness is recalled.
Not recall, sir. New witness is brought.
311, no?
Sir, I'm 311. I'm not talking about recalling. I'm talking about fresh witness being called, who is not there in the charge sheet, whose statement is not there, no connection is shown. Suddenly they bring a witness to fill in the lacunas.
Many a times it happens
Yes, sir.
that court may allow such a call upon an application made by the prosecutor. What care is taken that the IO sitting outside of the court hall in the corridor will record his statement, which he had not recorded, which he ought to have recorded during the course of investigation. He has not recorded. But now court feel that he should come. His evidence will always be in a doubt. Why he was not interrogated when there was a space of 60 days, 90 days to record him? Why the prosecution want to introduce? Because that will amount to filling of the lacuna. But court may, in the interest of justice, so as to give fair opportunity to the prosecution to further their case, court may allow it. What would be the evidentiary value of it? That is to be decided by the court.
Can I ask one more, sir?
Please.
Sir, there are sometimes witnesses well tutored, and so when they come to the court, whatever question we ask, is this a donkey? It's a donkey. They say, no, this is a horse. I was riding a horse. They will not answer the direct question. Whatever question we ask, they give a statement which favors the prosecution. So at that time, can we ask the court, kindly record his question and let the answer be also recorded in question answer form so that we know what the witness is trying to do, help the prosecution, or is a tutored witness. So we can request the court.
Yes, definitely. definitely.
Thank you, sir. One last question, sir. Sir, in a case of POXO case, they say that the most important witness is the victim, both for the prosecution and for the defense.
Who?
Victim in a POXO case. POXO case, sir. So when the witness comes, so she's the one who will establish the case. For us, defense also, she is the one who will demolish the case. So can we ask questions like, do you have a boyfriend? Did you have sexual thing earlier? So these are very relevant questions. But many a times we are not allowed to ask these questions. But these are very, very relevant. See, maybe the child is not
Bolu, sir.
that particular accused person's, somebody else.
Madam,
This is the last. Thank you, sir. Honorable witness, that's what.
cross-examination is not a character assassination
Exactly, sir.
of the child.
Exactly, sir.
Do you have a boyfriend? If you had a sex in the past,
Yes.
you are not supposed to ask this question, nor this amounts to the cross-examination. If you have firm information
Exactly. That is when we
that
ask.
she had a love affair with Ramesh, for example,
Exactly.
her college mate, her school mate. If you have a confirm information that they had travelled in a car to Guwahati, they stayed in a particular lodge, hotel, premises on particular day, there is an entry to that effect in that particular hotel or say lodge, you can come out with the positive case.
Yes.
Secondly, if they had chit-chatting on WhatsApp, Insta, and if you have collected that evidence and you feel that your accused is wrongly being implicated in the crime instead of him, you can ask the positive question.
Yes.
Do you know Ramesh? He stays next door to you. How long he is staying with you? So many years. Madam or child, you had gone along with him on a particular day, you can quote the date, to Guwahati. You had stayed here. I have got a registered which you have signed. That much concrete information which you can confront. You cannot say you had affair. If you had affair with somebody, that is irrelevant question. That's why court stopped you.
No, we can bring DWs to prove that. So in order to bring the DWs, I wanted to establish this particular thing in cross-examination.
Well, it is very difficult. DW is subject to cross-examination by the prosecutor.
Yes.
DW defense witness may damage your case,
Yes, I agree. But
may
it-
expose you.
Yes.
So you have to be on the guard.
Yeah, but no, the purpose of asking such questions is only to, when we have, DWs in mind.
Always in a cross-examination, whether it is a POXO, murder, or any criminal case whatsoever, small or big. Ask that question twice to you, posing yourself in the shoes of witness. You are a victim child. You are a victim of murder. You are a victim of 307, attempt to commit murder. Ask that question to you, what you would reply?
Yeah, that's true.
If you ask me, I am posed in the position of child, and if the lawyer asks me, if you had love affair before, I'll say no. Your question is gone. If you had sex with somebody else, no. Answer won't be yes.
Suggestion.
It is not a suggestion.
Can give suggestions.
Then, if it is suggestion, it must be concrete that you had love affair with Ramesh. These are the electronic evidence with me. You were active on his Instagram chatting, WhatsApp chatting. That you must possess.
So exactly with that, keeping DWs in mind, then only, sir. Thank you, sir.
Next.
Thank you so much.
Thank you.
Sir, hello, sir. So, with due respect to all the dignitaries here,
Please be loud.
sir, My question is whether tutoring a prosecuting witness by the prosecutor is permissible in law.
Refreshing memory of a witness
So
is
that is not my question. Refreshing the memory under 160.
Wait.
Yes. Please, sir.
tutoring means he will be informed about what the statement has been recorded by the police.
Yes.
So that amounts to refreshing his memory only. And that is permitted with the permission of the court. Refreshing of the memory. Memory relating to the statement what is recorded under section 180 of BNSS. That is allowed.
But in this juncture, this section is applicable in the cases which has been filed back 10 years, 5 years.
No,
but in
there
the
is-
cases which has been filed 2 months back, and the prosecution is taking the witness to some
Yes.
other room and giving tutoring for 2 hours, 3 years, and thereafter she has been put to the dice. So
I
is
know,
it
but
not
there is-
against the right of fair trial?
I know,
That's my
but
question.
there is no such kind of a bar under Bharatiya Sakshya Adhiniyam.
Thank you, sir.
Yeah.
See, the child had come from outside Bihar to Mumbai, Thane court, where I am practicing. Child was an eyewitness in the murder case. His statement was there. In between 3-4 years had gone. The child has grown up from 9 years to 13 years. He came with his mama, maternal uncle, because he was staying for 4 years with maternal uncle. Then mama brings him back to that place, Thane Bhivandi somewhere. Where they would go, poor people? They went to the police station. So police made their arrangement. You come stay, we'll give you bedding, we'll make your arrangement for food, sleeping, relax yourself. Morning you can take a bath, you can take your breakfast, cup of tea, and then we'll take you to the police station. Supposing small clue you have that this child has been tutored because it was in a custody of police for almost 12 hours, likelihood of police tutoring him is quite possible. You can put the child where you stayed overnight. We stayed in the police station. Then you traveled with mama all the way from Bihar to Mumbai. Lot of discussion took place between you and mama as to what you have to state in the court. He will admit yes. And mama, being your very close person, who is taking your care and maintenance, who is looking after your education, has told you, beta, you have to depose this in the court. Is it true? He will say yes. But if he has got down at Thane railway station and walked into the court at 1 kilometer and stepped in the witness box, if you ask that you have been tutored outside, you have to create a background with whom you came, mama. Then also you can say from Bihar to here, 1 day journey, mama and you had an interaction on the incident of death of your mother, murder of your mother. So mama has advised you, or as I told, he stayed in the... So tutoring, you have to bring it on record. Tutoring is not allowed. Refreshing memory, there is a provision. Okay?
So then my question is, if tutoring is not, it cannot be. Then
If
it is happening before the judicial person, sir, if it is happening before the judicial person, then it should be stopped by the judicial person, sir, or not?
No. It is allowed.
Yes. Thank you, sir.
But if you bring on record that he has been tutored, he has been trained how to depose in the court, say this, sequence. And if you could make out that he has been tutored by the police constable or the officer or his relatives, his family, you can ask and you can bring on record, because all victims in the POCSO, they are children, persons below the age of 18 years. Anything else somebody wanted to ask from this side?
Good afternoon, sir. That was a very lightning session. So there is one question I would like to ask. I've heard that sir is one of an expert in NDPS. You have handled lots of NDPS cases. So I would just like to ask whether GD entry is a source of information, sir. Because as per my understanding, if it is a source information, it has to be a documented written piece. Is it not, sir?
NDPS cases?
Yes, sir. Is GDA entry a source of information,
I
sir?
got it. General diary entry, station diary entry. Sit down.
Thanks, sir.
General diary entry is of course a good evidence. That has been told by Rajan sir that station diary entries are taken of everything happening in respect of this particular case. Then a case diary of each case maintained by the investigating officer. Now if you read section 42, it says NDPS Act. It says if an information has been received by a person, policeman, that somebody is coming with the contraband article at a particular place in Shillong city, so police can proceed. That is the foundation of the case. That section 42 says, makes it obligatory on the officer receiving the information to take it down in writing, number one. Not only that, he has to forward copy of that information to his immediate official superior. These two provisions you have seen, madam?
Yes, sir.
In 42, that will amount to the compliance of 42. And supposing information is not taken down, copy is not therefore forwarded, information which is a foundation of NDPS case, it becomes doubtful. You will get acquittal and you have to suggest no information was received. And if the officer who receives the information comes to the court, you have to ask him. You can't ask as to who was the informant, who gave you this information, what is his name. You can't ask that. You are not supposed, because that is a secret thing. You can ask at what time he came, what time he disclosed you the information. Details of information you can snatch from him during your cross-examination. All these things you can develop. You can ask his clothes also, what kind of clothes he was wearing, what was his height, what was his health, what was his age, but you can't ask his name and identity. You have to use your intelligence. Somebody from behind, please.
Good afternoon, sir. So my question is, if in a particular case there was a DNA report, it is regarding a POXO matter, and if the DNA report was already in the charge sheet, but the court chose not to frame charges against the different section, but whereas he completely neglected the DNA report and framed under a different section and convicted him.
Which section?
Section he framed under 5L of the POXO, whereas DNA report was there, but it was negative. So my question is, can the court completely neglect the DNA report and frame under different and convict him?
See, one good defense available in the charge sheet for you, that DNA report is negative. But prosecution doesn't become handicapped because it is negative. Prosecution can bring on record the documentary evidence from the hotel where they had gone, where they had sex. So he can be convicted under under section 6 for offence defined under section 5. All the time, in all cases, there may not be a DNA report. But normally speaking, when the DNA report is totally negative, I'll tell you, because the child is born. One may say that I had gone to that particular hotel with this girl, but we never had a sex. We were sitting, we were reading Gita, Bhagavad Gita. He may say that, and there is no evidence inside in the four walls. So to prove the paternity of the child, DNA report is a must. If not, then case weakens and it leads to the acquittal.
But sir, now he has been convicted, sir. So what is the remedy now?
What are the appeal?
That definitely yes, sir. That definitely yes, sir.
Go to the appeal.
One additional work.
One
additional
additional
work for you.
So one more question, sir. So if the prosecution repeatedly asks leading question, despite the objection from the defense, and court still allows, so what will be the consequences in conviction or a fair trial?
Just see that whatever has happened in the court goes on the record of the court. Sometimes what happens, we raise an objection that prosecutor is not allowed to ask a leading question, and practically witness unable to answer, and then prosecutor to bring those contents on record tend to ask that leading questions. And many a times this fight or debate happens verbally only. Court record doesn't say that whether what PP has did at that particular moment. So take care that this could be brought on record by filing some purchase or some document, or by moving some application that public prosecutor is doing like this. Whatever happens with that presiding officer, but then once you bring that fact on record, not over here, at least before appellate court, you can bring those facts on record. Always keep it in mind that asking a leading question by a public prosecutor happens almost in all cases, or many cases, or many a times. And we raise an objection, sometimes it is sustained, or sometimes court says that no, this much of leading is okay, or something like that. But then see that this goes on record. Request the court to record it during the course of evidence. If not possible, move an application. So it should form a part of record. Then admissibility or the effect of that leading question, whether it has got material aspect affecting the result of trial or not, that could be the part of job of a judicial officer. But our job to see that this particular conduct on the part of public prosecutor should go on record. We should request the court that this is what had happened. Sometimes demeanor of a witness needs to be brought on record. So we must request the court that it should be recorded in the evidence. Got it?
Don't fight with the court. Be polite and firm that he is leading. He is asking a question which includes an answer. And Supreme Court, in one of the judgments between 2012-13, has stated that prosecutor is not the agent of police. He is an independent agency. So taking examination in chief is a difficult job. In olden days, witnesses used to come to the court PP office on earlier day. The policeman used to read over them the statement under 180, that time 161. Explain them. Have you understood? Some illiterate person may come. So they were explained, and they were also told, if the learned defense advocate asks you that you have come yesterday, you have been told about, you have been prepared to depose in the court, you say no, I have not met anybody. We came yesterday, we stayed here yesterday in the court corridor, today we are here in the witness box. Don't admit that. These are the tricks. But taking examination in chief, I say it is a difficult task, and that's why my senior brother said it is an art, cross-examination as well as taking chief examination.
Show section 146 on the screen. Uh, 146, it is visible, na? You can read it. No, it was already there. Okay. So, I am reading 146(2). Leading question must not, if objected to by the adverse party, be asked in the examination chief or re-examination except with the permission of court. Now, take a note of if objected. If you do not object,
Last.
things will. And then number 3, the court shall permit leading question as to matter which are introductory or undisputed, or which have in its opinion been already sufficiently proved. So this is what the law says, that for minor things or just to lead him, just to start, he can ask. But that doesn't mean that on material aspect he can lead. Okay?
I think we have
Next
time for
question.
maybe one more question, please. Yeah, thank you.
Take a seat. Yeah, he can sit with us.
Good afternoon, sir. So my question is regarding contradicts in section 181 of BNSS and of 148 of BSA. So my question is this. So whether the defense counsel can contradict a witness using their statement recorded under section 180 of the BNS, even if the witness disowns the statement in court by claiming that the investigation officer never recorded it.
See, if he disowns, this will have a serious impact. Contradiction we are bringing on record to show that there is a difference or a contradictory version coming from the mouth of the witness. If he disowns that at no point of time statement has ever been recorded, then will not able to confront that particular portion. But the moment you get an admission that there was no statement ever recorded by the police, that means we are in more better position than to bring a contradiction on record. Am I clear?
Yes, sir.
Yeah.
But if in the charge sheet, sir, the statement is there, I mean, police is recorded, but the witness disown it.
Put to the IO, we can still, there is one more witness to bring it on record, no? If you still feel that there is some portion in the statement which can demolish the entire prosecution case, still we have one more witness in hand. That is an investigation officer to whom we can ask that whether you recorded the statement of such and such witness, what revealed in the investigation. Now, since there is no portion mark ABCD with us, so we'll skip section 148 and we can ask him about the investigation as to what revealed to him during investigation. See, there are something happens where witnesses are not examined by the prosecution. Not at all, means there is no evidence while recording the evidence. And we feel that there is something more important or favorable to the accused in the statement of some witnesses which are not examined. So we can bring those contents on record while cross-examining the investigation officer. Only you will have to frame your questions in a different way. We have to ask him whether he has recorded statement of witnesses A, B, C, D. Then we have to ask what revealed to him while interrogating those witnesses, and put those contents which reflect in the statement of those witnesses. Am I clear? Next question.
So I think maybe we can conclude for the days. I think so.
Thank you, sir.
Yeah. I want to thank all the participants for actively participating and asking questions. And more importantly, I want to thank the eminent resource persons for giving us concrete answers and not skirting around the questions. I hope this...
Sir, before you conclude, let one of the participants express about the...
Oh, no, yeah, we'll give them time, sir. We'll give them time after this. Also, we hopefully after this question answer, this interactive sessions, it'll help us eschew any remnants and anachronistic practices that we have, especially when it comes to sexual offenses and POCSO, that we'll be able to deal with empathy and with sensitivity when it comes to survivors of sexual offenses. Before we move on to the concluding remarks, may I kindly request Jacqueline Karmaki, Madam, to kindly felicitate Shri Jayant Jebhave, sir, who is an advocate of more than 35 years of standing. Sir is a member of the bar and former chairman of the Bar Council of Maharashtra and Goa. He's an author of 6 legal texts, which are the civil pleading, conveyance and drafting, cross-examination, civil and criminal matters, CPC's approach to civil trial, Hindu Succession Act, Law of Wills, and Marathi book on CPC. Sir was also the chairman of Bar Council of Maharashtra from 2010 and 11, vice chairman 2008 and 9, former member of Bar Council of India, current member of Bar Council of Maharashtra and Goa. He was also the member of the Maharashtra State Law Commission, Governing Council of the MNLU Nagpur, Academic Council, MNLU Mumbai, member of the Legal Education Committee, BCI Delhi Advisory Committee, Bombay University. Sir has conducted more than 700 plus land references across 20 awards, including CIDCO acquisition for housing at Nashik. Here, Sir deals with civil matters, revenue matters, sessions trials, NIA Act cases under Section 138, and other criminal matters. Sir is also an expert in arbitration and consumer disputes. Some of the key contributions of Sir is that he was the person to first establish the computer law library in India in Nashik into the year 2005, which has expanded to 425 locations across Maharashtra and Goa. He has initiated continuous legal education programs and trained more than 3,000 young advocates. He ran the judicial service as a career training, out of which 250 trainees have joined the judicial service. He's a trained mediator with having more than 60 matters resolved and a panel judge in more than 125 Lok Adalats. And so has been an expert speaker and guest lecturer for more than 20 plus years. With this, I once again thank all the eminent persons for giving the time and also all the participants for very actively participating with us. As I think there's a consensus among the participants, especially the LADCS, that the concluding remarks might be given by the Chief LADC from East Janthias Clariat. Madam Rimaya Manar, if you could kindly come up and maybe give a concluding remarks or maybe a feedback to the eminent resource persons, I think that would be much appreciated. Thank you.
Distinguished guests, esteemed resource persons, Shri Gajanan Chavan sir, Shri Rajan Salunke sir, and Shri Jayant Dattare Jebhave sir, and learned colleagues, and my dear participants. As we have come to the conclusion of this training program for the Legal Aid, Chief Legal Aid Defense Counsel and Legal Aid Councils and all other defense councils, I extend my sincere gratitude to each one of you for your active participation throughout thoughtful engagement and unwavering commitment throughout these enriching sessions. Today, from all these 3 sessions, we have revisited and strengthened the core principles and define effective criminal defense advocacy. Through this comprehensive discussion on criminal trials procedures, the arts and science of cross-examinations, and the skills of courtroom advocacy, we have not only enhanced our professional competence, but also reaffirmed our shared responsibility to uphold the rule of law and ensure access to justice for all. The role of a legal aid defense counsel and all defense counsels is a challenging and noble role. We stand as the guardians of constitutional guarantees, ensuring that every accused person, regardless of their social or economic background, receives fair representation and a fair trial. In this regard, effective advocacy is not merely a professional skill, but it is a tool for safeguarding fundamental rights and preserving public confidence in the justice delivery system. These sessions today have reminded us that successful advocacy requires preparation, strategy, patience, and a deep understanding of human behavior. A well-conducted cross-examination can uncover the truth, test the reliability of evidence, and ensure that justice is served. Equally, our discussion on advocacy skill have reinforced the importance of clarity, ethics, persuasion, and professionalism in every courtroom appearance. I express my heartfelt appreciation to our distinguished resource persons and trainers for today, who generously shared their knowledge, practical insights, and valuable experience. Their guidance has undoubtedly enriched our understanding, and equip us with tools that will enhance our effectiveness as defense counsels. I also commend the organizer of this program and the supporting staff whose dedication and meticulous planning made this program a success. Their efforts have provided a valuable platform for learning, reflection, and professional growth. As we return to our respective assignments and our daily routines, let us carry forward the lessons we learned here today. Let us continue to sharpen our skills, uphold the highest standard of professional ethics, and remain steadfast in our commitment to providing competent and compassionate legal representation to those who depend upon legal aid services. May this training not only mark the end of our learning journey, but rather serve as a renewed beginning, one that inspires us to strive for excellence, fairness, and justice in every case we undertake. With these words, I thank you for all of your participation, and especially I thank all the resources persons for giving us this opportunity to learn and to improve ourselves in our everyday to-day court practices. Thank you. Jai Hind.
We have come towards the conclusion of the session, I think, but before we part, sir would like to say a few parting words, maybe some concluding remarks. So we give you time till the end of the session, sir.
Mainly, we are thankful to Honorable Chief Justice of the Meghalaya High Court, Honorable Justice Revati Dere Mohite. Let us give a big hand for her. I hope that during her tenure, there will be more such type of a program, because it should be a continuous learning. Not only the juniors, but many seniors lawyers have contributed their valuable time. And I will also thank to Honorable Sri SP Mahanta sir. Thank you very much for contributing time. And of course, whenever a call will be given by you, will be always available for your disposal. Also, Honorable TTM Sagma sir and Sri BN Sagma sir, they had contributed a lot. So let us give them a big hand. And thanks to the Legal Services Authority of the Meghalaya High Court. Yesterday, the Honorable Member of the Bar, Mr. K. Paul, was there, and he has contributed for organizing. Also, Honorable Members of the Bar Council are there. So we are thankful to them, and mainly many Honorable Judicial Officers have attended this seminar online. We are thankful to them. We are sure that whenever any sort of association is required with your bar and the Legal Services Authority, we will be definitely available to you. We are very much impressed by the hospitality which has been shown by all the staff members of the Meghalaya and all the bar members, and it will be a pleasure to visit again whenever you will require. So thank you very much. Whatever material is available for this program, because we are conducting such type of a program for last continuous 15 years, and we had a academy established, first time of an advocate training academy established at New Mumbai, a big institution. If you have any opportunity to come at Mumbai and see that academy, we welcome you. And also yesterday we had a talk with Honorable Chief Justice, Madam. We have started one online training program through this academy for use of artificial intelligence in a legal research work. So that invitation we will send to your bar. Whoever want to join online, it's a 6 months online program. Every Saturday or Sunday there will be online lectures. And the Computer Society of India is in collaboration. So experts from this field of an artificial intelligence will give us information how to use the artificial intelligence for skill development in our profession. So we will like to invite you to join this online program. And thank you very much. We are very much privileged to participate in this seminar. On behalf of my 2 senior colleagues, members, and on behalf of my Bar Council, I express thanks. Thank you very much.